Good morning, Your Honors. This is a continuation of the public panel interview of the candidates for the position of Supreme Court Associate Justice, Vice Honorable Associate Justice Mario V. Lopez, who will compulsorily retire on June 4, 2025. Please all stand for the centennial prayer for the courts.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Please be seated. Let me introduce to you the members of the Judicial and Bar Council who are present in today's public panel interview. We have the Honorable Justice Jose Catral Mendoza, JBC Executive Committee Chairperson and regular member representing the retired justices of the Supreme Court. Honorable Attorney Nesauro H. Firme, regular member representing the Academe. And Honorable Justice Erlinda Piñera Uy, regular member representing the Integrated Bar of the Philippines. May I now refer you to the Honorable Justice Jose Catral Mendoza to officially open today's public panel interview.
Public panel interview of the candidates for the position of Associate Justice of the Supreme Court is hereby open.
Your Honors, the candidates to be interviewed today are Honorable Court of Appeals Associate Justice Ronaldo Roberto B. Martin, Honorable Sandigan Bayan Associate Justice Karl B. Miranda, and Dean Maria Concepcion S. Noce. May we request all the candidates to please stand up and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview of the JBC? So help you God. Thank you. May we request Honorable Justice Martin to please take your seat in the middle po. And Justice Miranda and Dean Noce to please proceed first to the holding area. Thank you po. You may take your seat po, Justice. Your Honors, the first candidate to be interviewed this morning is the Honorable Court of Appeals Associate Justice Ronaldo Roberto B. Martin. Good morning po, Justice Martin.
Good morning, ma'am.
The first to interview Justice Martin is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good morning, Justice Martin.
Morning, ma'am.
I have two sets of questions. The first set are questions from the Secretary of Justice, and then I will, to be followed by my own questions. So I will start with his questions. Number one, you were a legislative staff officer of the Senate before joining the judiciary. How did your experience in legislative work influence your understanding of statutory interpretation and your approach to resolving ambiguities in the law?
Correction, ma'am. I was first a legislative liaison officer for the Senate, and then I entered the OSG before joining the judiciary. Anyway, as far as my experience with the Senate is concerned, I basically assisted in the crafting of laws, and my most specific experience is crafting a law with respect to my principal was with respect to Republic Act 6713, or ethical standards for government officials. And in the crafting and in the production of said law, we basically created standards or guidelines by which all officers, officials of government must adhere to. And as a government official myself, then and up to now and up to the judiciary, I adhere to those standards as much as possible, in as much as I help or we help create or craft the said law.
Second question, your extensive experience in family law cases, including nullity of marriage, has been recognized with your publications on the subject. Given your expertise, do you believe the current family code of the Philippines needs to be revised, particularly on the grounds for nullity/separation of marriage? And what about divorce? And then why or why not?
Just to correct again, I don't claim any particular expertise. It's just that it's my field of interest, so to speak. Nullity of marriage or family law in particular. With respect to the question of if there's any aspect of the family code that needs to be amended or revised, I don't think so. I think it's very responsive to the signs of the times, and especially on divorce. I think Article 26 of the family code best addresses the issue of divorce, specifically the second paragraph. It is where I crafted my first article entitled the procedural and substantive issues on nullity of marriage from Tanaka to Takahashi, including divorce, for specifically on petitions for recognition of foreign divorce.
Number 3, you have experience involving human trafficking laws, sexual abuse, and exploitation of children through your work with the Justice Sector Coordinating Council. What specific judicial reforms do you believe are needed to improve the protection of children and trafficking victims?
Actually, it's not only for in response to protection of children, even the adult victims. But let's focus first on the children, ma'am. Under current jurisprudence, the unavailability of the child doctrine is very much appreciated as far as the stakeholders are concerned. We know for a fact that having them go through the witness stand is another opportunity for them to be re-victimized and re-traumatized, and for them to be exempted, quote unquote, to testify based on the rule of examination of child witnesses, which allows for hearsay evidence. I think it's very much proper and very much considerate of their plight. I would like, if there's any amendment or any modification I would aspire or desire, I hope that one day it also applies to adult victims, because I don't see any substantial distinction if only we're talking about the age. On the issue of re-traumatization and re-victimization, they can very well be re-victimized themselves or re-traumatized once they appear or they see the offenders that caused their misery. So if there's any amendment or modification, it's with respect to that somehow if they are unavailable or unwilling to testify based on fears which are actual, I hope one day there's a jurisprudence that would actually enunciate the doctrine that even adult victims, if they feel they are not well equipped to testify, then so be it. Anyway, what they want to prove can be proven by other evidence, like the testimonies of police officers, social workers, which is the same also with respect to the children.
Number 4, it can be said that our Constitution shares some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our constitutions?
Yes, I think the constitutional principle of the right to liberty, right to be secure in one's home and property and person is very much protected by our Constitution and the U.S. Constitution. However, one particular point of interest that I'm particularly, shall we say, aspiring or desiring is with respect to the writ of amparo, which is not really U.S. in origin, but South American nonetheless. So as far as the writs of amparo are concerned, in as much as it also adheres to adhering to the constitutional right of persons to be secure in their persons, in their liberty, I would somehow want that particular aspect of American law or South American jurisprudence be enshrined or bolstered or strengthened in our jurisprudence as far as the writ of amparo applications are concerned.
Number 5, with your long years of practice of law and now as an applicant for a Supreme Court Justice position, can you share your judicial philosophy?
I'm thinking if I have one. But I think I have. My judicial philosophy in relation to my books that I have written is the advocacy of making law simple and understandable for the not only for law practitioners but law adherents or the ordinary layman. And in that aspect, that's my advocacy, to make it simple, free from legalistic jargons, which essentially differentiates all professions from the other ordinary professions like the medical field, or even the sports profession. We only differ in terms of the jargons we utilize and use it as basis to charge our clients more. But on the final analysis, if you do away with these jargons, even the ordinary layman will understand it. That's why, as far as my judicial philosophy is concerned, I write the way I speak, and it is how I speak is simple. I use very simple adverbs. I use the reportorial na way of exposition of my narration of facts, and then I explain simply using again simple verbs. I think that's just my, if I can think of a philosophy of mine, of as far as my judicial experience is concerned, is simplicity.
Follow-up question from me. Have you practiced this in your decisions in the CA and the RTC?
Yes, ma'am. In my narrative, as I mentioned, it's always reportorial. I don't quote, for example, as far as certain decisions of other juries are concerned, they quote the prosecution, the version, they quote the defense version. I don't, because I am under the impression that if I do so, I would betray my bias right away if I quote from a particular version. Always, as far as my narrative is concerned, my statement of facts is always reportorial, meaning, for example, the prosecution alleged that so-and-so, the prosecution contended that so-and-so. It's never that I adopt their version. And I do the same with respect to the defense version or the respondent's version, if only for the fact that I don't want to betray my biases as far as the initial narration of facts is concerned. In fact, in the first paragraph alone, I go straight to the point. I don't quote quotations from different authors or whatever. I always go straight to the point that this is a petition, for example, for certiorari under Rule 65. That way, it's very clear from the start. And I go through the narration. It's also clear. I also simplify it in respect to the issues. I only go to one or two issues, never enumeration of kilometric issues. And then I explain my decision.
And is it safe to say you practice this even during your RTC days?
Yes, ma'am. Because it's more economical. In the RTC, when I was at Antipolo, I started with 3,000 cases when I arrived. Mostly because the computers were outdated. But nonetheless, with the use of simple language and simple exposition and simple narration and economy of pages, I was able to come up with an output that would best lower my docket. In fact, after 3 years, I was able to reduce my output to 1,000. But nonetheless, then Justice Sereno, when I applied for the CA, took it against me why I had 1,000 cases. But she didn't know that it started from 3,000. I just wanted to explain that, ma'am. Sorry.
Do you have a particular justice here or elsewhere whom you consider an idol and why?
Besides Justice Firme, who is my basketball buddy, is not included in the justices, I suppose. No.
Siguro,
Can I give me
justice.
30 seconds to think?
Okay. Here or elsewhere?
I don't know elsewhere. I'd rather stick to here. I think it would be Justice Antonio Carpio. And can I explain?
Yes, why? The next question is why?
I believe that among the three branches, the judiciary is the least known, primarily because we cannot explain our cases. But we don't have to. We don't have to explain our cases. It's just that we have to be heard. Why again? Because I think we're the most rational personalities in the three branches of government. Why do we have to explain not our decisions? Because it's prohibited. But we can explain other issues. Like for example, Justice Carpio, he explained the Southwest Philippine Sea exposition very well. And it was understood by majority of the Filipinos. And I think it's beneficial. And if we adhere to being silent all the time as far as juries are concerned, it will do the country a disadvantage. So if you ask me who was my justice that I can look up to, it's him, primarily because I believe that even juries have to be heard.
Assuming you were appointed to the Supreme Court and given this would be 10 years?
In my CA experience, ma'am?
Should you be appointed? How many more? You're now 60 years old?
Yes, ma'am.
So given the 10 years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
Contribute. One thing I learned from joining committee works of the Supreme Court, which I was initially averse of joining, is that judiciary work is not purely adjudication. When I joined several committees, specifically on Committee on Gender and that particular committee on justice zones, I learned or I realized I was open to the realization or the fact that the work of justice goes beyond adjudication. And what I've learned in the committee work is that there are certain programs or plans of action that has to be implemented. And honestly, there are several programs within the Supreme Court that has been pipelined in line with the SPJI. As far as the monitoring and effectivity or the learning of those programs are concerned, that's a different matter. And if I will be fortunate enough to be appointed to the Supreme Court, I would ensure or I would help in the creation of a unit within the Supreme Court precisely to monitor, evaluate, and see perhaps where to learn based on the experience of these programs so that we can better modify, improve on the said programs.
In the context of criminal law, how do you reconcile the principle of nullum crimen sine lege, no crime without law, with the evolving nature of crimes in the digital age, such as cybercrimes and artificial intelligence-assisted offenses? Should the judiciary have the power to recognize new crimes absent explicit legislative provisions?
I'm sorry, ma'am. It's a compound question. Can I have it repeated just one more time so that I can also be given time to think for my answer?
So in the context of criminal law, how do you reconcile the principle of nullum crimen sine lege, no crime without law, you compare this with the evolving nature of crimes in the digital age, such as cybercrimes, artificial intelligence-assisted offenses. So should the judiciary have the power to recognize new crimes absent explicit legislative provisions? So you tie that up with the doctrine that no crime without law. There is no crime without law.
There's no crime without law, but with respect to cybercrime provisions, there might be some conflict. Is that a particular question? That such that can the judiciary interpret such scenarios or such circumstances so as to address the problem? As far as my understanding of the question is concerned.
Should the judiciary have the power to
Ah.
recognize the offense absent any law on that matter, considering the digital
Yes,
age
okay,
that
now
we
I
are in?
understand. Short of being accused of being a judicial activist, I think the judiciary must even have the power to address evolving scenarios, because we cannot call it crime at this point, if it will somehow affect or make the public or injure the public or make the public be at a disadvantage. As far as the law that to be based on is concerned, I think we can always look outward to US laws if there is no law at a particular time in our jurisprudence at this point. The fact that it has no law, there's no statute, it has no administrative circular to that effect, maybe the Supreme Court can make administrative circulars to address the absence of that law, basing it, as I've said, on US laws or other laws for that matter. I think that is the experience of the writ of amparo. Initially, we don't have such writ, but looking outward, the writ of amparo and even writ of kalikasan and the other writs for that matter were based on outside experiences, outside of our jurisprudence. So to stifle the judiciary, particularly the Supreme Court, just because of the absence of such law, I think it's not beneficial for the state or even our countrymen.
Number 9, the principle of proportionality requires that the punishment must fit the crime. How do you view the constitutionality of mandatory minimum sentences, which limit judicial discretion? Should the judiciary have the authority to invalidate such laws if they lead to unjust results?
I think that will be just judicial legislation if we invalidate the law. But if it is extremely severe in proportion to the actual act or circumstance brought about the perceived offense, okay, I think it is up to the Supreme Court to issue such administrative circulars, and I don't think it will be a violation of any separation of powers, especially in relation to the legislature. So I do believe the Supreme Court is its evolving powers and jurisdiction, and I trust the Supreme Court, especially the magistrates therein, to address the problem of whether certain offenses and in relation and comparison to the applicable penalty are too severe and not proportionate, to come up with remedies to address the problem.
Last question. In your view, does the doctrine of presumption of innocence extend beyond the trial stage to public perception and media coverage? And how should the judiciary protect the presumption of innocence in an era of widespread media sensationalism?
Yes, ma'am, I do believe, because in the era or advent of fake news, all the more we should presume any utterances, any personality is perceived to have violated a particular offense, a particular crime within the revised penal code, and presume him innocent at any stage, whether it's post-arraignment or pre-judgment or even pre-conviction or pre-acquittal. So at any stage, I believe the right to presume innocent is so vital that And as I've said, in relation to the advent of fake news.
So that was the last question of the Secretary of Justice. You have given thorough answers, so I have a few questions of my own. May I know if this is your first time to apply for the position of Associate Justice of the Supreme Court?
This is my second, ma'am. My first application was for 4 vacancies. Unfortunately, fortunately, I was interviewed twice for that 4 vacancies. So this is my second application, but my third interview.
Were you shortlisted
In the last, ma'am, fortunately,
for the
yes.
4 vacancies?
No, just the last.
So for the 4 vacancies, you were not shortlisted?
The fourth.
At the 4th.
The fourth, ma'am.
Fourth.
Where Justice Singh, my classmate, was appointed.
Oh, she was your classmate?
Yes, ma'am. But
See.
it doesn't look so, I believe, because she looks much younger. And I admit that.
In your 19 years in the judiciary, 10 years in the Court of Appeals, and 9 years in the RTC, what challenges have you encountered and how did you resolve them? Was your sala a regular court in the RTC? Or is it a special
Actually, I
court?
started as a heinous court. And then, because of my experience in the OSG, the incumbent family court judge at that time asked help from the Supreme Court, and I was designated as a family court. And I was happy to be designated as a family court. But I was also handling heinous court at the same time. And as far as my experience is concerned, it is more heinous to address the problem of family courts than the heinous court itself. So again, sorry, the question is
What challenges have you encountered?
It is the perception, or overcoming the perception that judges and juries are like lackadaisical or unemotional in the way they approach their work. That's why I gave the answer, ma'am, that somehow juries or justices, especially justices of the Supreme Court, should be heard, not necessarily about their cases, because so as to avoid such challenge of being perceived as inactive, being lackadaisical or unemotional. Because I am on the contrary, I am emotional. I am not lackadaisical. And at the same time, I'm active. But somehow, during my experience in the RTC, I was perceived as the opposite. Because of the general impression of what a jurist or a judge is or are. So I think the biggest challenge is that, overcome that presumption. But I don't see it as a disadvantage. I just work as far as I want to and as far as I can afford. But as far as the challenge is concerned, it's particularly resolving that discrepancy or misconception as far as the public is concerned, because somehow it affects or redounds back against the judge when the public perceives us as such.
How about in the Court of Appeals? Any challenges you
Oh,
encountered?
many, ma'am.
Huh?
Many challenges. Can I just talk about one because it's one closer to my heart? I think adhering to the principle of seniority for seniority's sake is one challenge I have learned to confront and address within the Supreme Court. I believe that seniority has its purpose, but if it is being considered too much to the point that certain issues or problems are not being objectively addressed to, and always the answer is seniority, then we will have a problem. And I have problems with respect to that, especially during our deliberations, especially during our draft decision making. Somehow juniors are perceived to be, and I was the junior once, to be inexperienced, that our opinions somehow do not matter. But I have made it a point ever since I was a junior to stand for what I believe what is right and stick to what I believe are my principles are. And it's very hard to work in an environment that believes that a principle of seniority is paramount. Now that I'm a senior myself, now that I'm a chair myself, I encourage the juniors to speak out and even oppose me if they perceive to, because I think that is very, very, very healthy in a collegial body such as the Court of Appeals.
How about any significant case or legal decision you have rendered which had a profound impact on you? You don't have to mention the names of the parties, just the impact and the nature of the case and what was your experience.
I have two cases I mentioned in my PDS. The Sagesaka case is petition for recognition of divorce, especially because it's my field of interest. The other is the writ of amparo case, which I decided. But the impact...
Involving what city?
City, ma'am?
Writ of amparo, so it's a personality. I
Yes,
was thinking of kalikasan, I'm sorry. So the writ of
Amparo.
amparo, yes.
Yeah.
Someone
It's
was
in my
being
PDS.
threatened.
Yeah, it's an enforced disappearance.
Oh.
It's very hard to sometimes favor petitioners because there's no evidence whatsoever sometimes. It's basically hearsay. So as far as the impact is concerned, you want to help, especially at the time of the previous dispensation. It was such occurrences, I would say, prevalent at that time. And it started at the time, but yeah, I think it was during the time of the previous dispensation when we issued the writ of amparo. So it's very hard to resolve the problem or the case, okay, especially since I was at that time applying for the Supreme Court. But somehow I resolved it, and the impact on me is that never to be fearful if you believe a particular case is to be decided in such manner, never mind the consequences. So as far as the impact is concerned, the writ of amparo case is what I consider impactful as far as my case experience is concerned in this Court of Appeals.
In your PDS, you mentioned two character references.
Yes.
One is Justice Ami Lazaro Javier. How well does she know you?
Very well, ma'am. I started my career in the OSG, and she was the Assistant Solicitor General. The other is Karl Miranda, who is my co-applicant here.
Right. That's my question.
Yes.
Yes. Who do you think? Alam ning should be. Who do you think is the best candidate?
Of course,
between the
ma'am, ako.
Can we quote you later?
Is that your question? Who is
Yes.
Yeah,
And
without
also, I
batting
think
an
the
island, I
question-
think I'm the better candidate. But he's more good looking, I will admit that. But as far as, no, I think he's also a well-equipped, deserving candidate. I just like to explain why he is a
You are
reference.
younger.
Definitely, ma'am.
Oh, okay. So please explain
Yeah.
why it should be you and not him.
I have no problems if it is him, but for a very self-serving principle and explanation, of course, I would like it to be me. But if he is appointed, I will be the first to congratulate him.
Does he know you
Very
placed his
well.
name in the character among your character?
Can I explain, ma'am, why I chose him?
Yes.
Yes. He is, we both, nag-abot po kami sa OSG. Okay, and he was, at that time when I was starting, detailed with the office of the Blue Ribbon Committee of Senator Pimentel. And there was one case that I handled where I was bribed a hefty amount, okay, so as to drop the case, patalo, ika nga. And the previous handling solicitor was Karl Miranda. And the person who was offering me the hefty amount explained to me that they cannot bribe Solicitor Miranda because he is already rich, owning Miranda Bookstore. So I was particularly flabbergasted and insulted because somehow it gave me the impression that I don't look rich and I am easily bribable. At any rate, I told him, and knowing that he is detailed at the Senate Blue Ribbon Committee, I told him about the problem. This is your case, but I don't know him. I didn't know him at the time. I was a new lawyer. I said, Justice Karl, Judge Karl, we call each other Judge 10. This is the case that you handled, and it is uh, reversion case involving the Property and Air Transportation Office in Pasay. Cancellation of title. The one who surreptitiously and maliciously had the title was the one offering. And I told him, you better help me because if you don't help me with this case, I might lose the case and not only will be detrimental to the state, but I might be perceived to have accepted the offer. And I told him that the story that he was not bribed because of your appearance that you're so rich. So since then we have known each other, and I appeared at the Blue Ribbon Committee to testify on such situation. And somehow, at the end of the day, we won the case.
Is that an answer to my question? Who is the better candidate?
I already answered, ma'am. I said
Okay,
I am the better
okay,
candidate.
We will take note of that.
But don't tell him when it's time to interview him. Please, ma'am.
What is your opinion regarding Supreme Court decisions which overturn judicial precedents, and what would be their impact, if any, on final and executory cases pending in the lower courts?
What is my opinion, ma'am? I think if the abandonment of the principle or the doctrine is timely or proper, I don't have any problems with the abandonment of principle. I can give an example. The condonation doctrine enunciated in Carpio Morales versus Binay. I think it was a very much abused doctrine. And it was abandoned on time. And I used it in one of my cases. That's why I know. So I have no problem if that's the question of abandoning legal doctrines.
And what is its impact on decisions of the lower courts, which are now final and executory?
That's why
And they can no longer go up on appeal.
yes, ma'am. A particular example I gave, the condonation doctrine, had a particular impact on me as a lower court, a court of appeals justice. Because I think the application was proper. Certain elected officials have been abusing the power of re-election and condonation, that certain misdeeds have been repeated and repeated. All they have to do is just be re-elected. So what is its impact on the lower courts? I don't care. The problem is, the better question is it beneficial to the general welfare concern or even jurisprudence? I think it does. It is, ma'am.
What about the Iron Curtain Rule? What's your comment about the recent ruling on that matter?
The Iron Curtain Rule is with respect to the grandparents and
Whether it's still
marital,
applicable or no?
non-marital
Yes.
children. Yeah.
Have you read the decision of Justice Leonen? I think?
Yes.
What is your comment? You agree?
Yes, ma'am. It's, so far it benefits the non-marital child, he or she can inherit from the grandparents. It's only on the horizontal aspect of the relatives that it is prescribed, right, ma'am? As far as the Iron Curtain Rule is concerned, I agree with it, ma'am, wholeheartedly. Insofar it benefits children, especially those previously considered illegitimate or now called non-marital children.
What are the limitations on Congress in exercising the power of legislative investigation?
The limitations, the subject matter primarily must be in aid of legislation, the first and foremost. And the other powers of, or limitation, that's question, is the power to issue contempt powers, which I think is the question during our exams. There are three limitations.
The Harry Roque case.
Harry Roque case you're
Yes, you were
mentioning.
talking about contempt.
Ong and family, the case is what I was thinking. The Harry Roque case, yes. I think this is in relation to the.
No, I'm not asking you about the Harry Roque. I just mentioned it in passing. What are the requirements or limitations?
It must be in aid of
That's
legislation.
one. There are two more.
it must be respectful of the rights of the party, especially those sought to be as resource persons.
Yes, and one more.
And the third is the rules and procedures must have been published. And actually, there's a fourth. That
Okay, yes, an additional fourth.
is that what's the fourth? Why did I even mention there's a fourth?
You said there is one.
Yes. The time frame by which the in age of legislation inquiry or even the contempt power of Congress must be only to the time frame of the congressional investigation.
Right.
Is that the fourth, ma'am?
Yes.
Thank
What
you.
is the constitutional policy of avoidance? What do you understand with that policy?
I think it's with respect to the separation of powers, instrumentalities of government.
It's about attacking the constitutionality of a statute.
I think it's about the powers of the different branches of government. Avoidance, ma'am. Yeah.
Yes.
Constitutional principle of avoidance as
On-
much as possible.
On the constitutionality of a statute.
Constitutionality.
Yes. How should you practice it? Should you be appointed in the Supreme Court?
Insofar as it gives overbreadth or broad powers for the judiciary to investigate or inquire as to the acts of other branches of government. I think it is unconstitutional to do so because precisely we should avoid overreaching the powers and authority of the other branches. However, if there's an overbreadth or grave abuse of discretion due to the expanded jurisdiction of the Supreme Court on basis of the other branches committing abuse of discretion in the exercise of that power, then I am for the review of the Supreme Court, especially once I'm appointed.
Labor law. Are you familiar with labor law?
A bit, ma'am, because I practice
How
labor
about in
law.
the CA? You have
Yes, of course, ma'am.
decided
I
labor
thought about
cases.
practice.
No,
when I-
labor cases
Yes, ma'am.
in the CA.
Petition for certiorari cases from the NLRC.
In illegal recruitment, may an estafa case be filed separately if there is already an illegal recruitment case?
In an illegal recruitment case,
And then can the accused also be charged for estafa separately?
I'm not quite sure, but can I venture an answer, ma'am, based on
Yes.
yes? I think estafa is essentially about deceit and damage. And illegal recruitment is mala prohibita instead the mere fact that they are recruited illegally or even minors are recruited. It has different issues and cause of action. So I believe it can be separately instituted.
All right, the yellow light is on, so I will stop there. Good luck to you, Justice Martin.
Thank you, ma'am.
Thank you, Justice Uy. Our next interviewers, the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Cuevas. Good morning, my basketball mate.
Morning, sir.
So how did you prepare for today's interview? Like practicing during the basketball?
I believe physical aspect of every endeavor is very important because if you not have a healthy body, you cannot recall whatever you have read or studied.
Yes, I was about to ask you, how is your health? Because I understand you had a surgery. When was that?
13 years ago,
13
yes.
years ago. Since then, you've been good.
Yes, sir.
Are you taking medications for that?
Just maintenance because every person who has a heart bypass must take maintenance medication. But it's essentially
Are you hypertensive? No, no.
not anymore. But to be
What caused that? What's that?
blockage of the major artery. It was only one artery. I have a physical defect at the time. I overproduced calcium. And my good cholesterol was high, my bad cholesterol was low. But the problem was my physical defect is that I produced too much calcium. So it was blocked. That was the blockage as far as the artery is concerned. That I was still 43 years old at that time. But since then, I have no more problems. I have no more heart problems.
So maybe your love life is good. So, if appointed justice, what would the stakeholders expect from you?
Stakeholders, I think this is the general public as a whole. I think they can expect from me, as I mentioned, to stand up for what I believe in. I will have no problem confronting or engaging friendly banters, senior justices, even in the Supreme Court. If I believe I have an opinion that is worth defending, the stakeholders can believe that I will do so, regardless of personalities.
I was about to ask you about your character reference, but it was asked earlier by Justice Linda. Well, maybe I can tweak it. So the question would be, why not Justice Karl Miranda?
Why not Justice Karl Miranda? Because there are people who believe we practically look alike. We have the same facial features and mannerisms. So if the question is why will not I pick him, because I might be mistaken for him, and if he answers incorrectly during the interview, it might be taken against me.
Okay. I heard earlier also about your favorite, our idol, Justice. And I understand Justice Ami is one of your character references. Is one of your character references. So why not her as your idol?
Why not her?
This is, by the way, recorded.
Yes, ma'am. Ay, sir. Yes. Why not her? Academic reasons. Because,
Up to you.
yes,
Justice.
my particular field of interest is petition for recognition of foreign divorce. Although I believe in the cases she handled in Takahashi and Kondo, I have certain issues in how it was arrived at. So why not her? I think that's one, because if I air my my comments, she might not like what my comments are. But I already mentioned her in passing in one of our friendly discussions. But give me a reason not to select her as my reference. That's one of the reasons I could think of.
Okay. So, Justice, you're aware that 14 cases, by the way, no, I'm reading also the questions from the academe sent to me. No? As I do with other applicants, you have 14 cases filed against you, both as a judge in Antipolo and now as a justice of the CA, Court of Appeals. What have you learned from those cases?
What have I learned from those cases? To be careful. Because most of the cases were dismissed primarily because certain personalities who filed the cases were unknown. And not one of those cases ever progressed to be an administrative complaint against me. In fact, in my earlier interview, I was asked, I was the most, and it appeared in batas.ph that somehow painted me as the most number of cases complained about. My answer to that was, out of the 3,000 who I litigated, only 14 or 16 filed against me. That's minuscule. But what have I learned is the question is that, yes, to be careful, regardless of the fact that those were dismissed, any personality, disgruntled or otherwise, can easily file a case. And as I mentioned, 14 is quite, or 16 is quite a minuscule number, just the same. I ought to be careful. In fact, I had adhered to my public life as a judge. I don't normally go to social events because I don't want to be perceived as associating with especially practitioners. Even in the gyms that I have participated or been a member to, once I am known by a individual, litigant or not, I automatically withdraw from the gym membership.
So, you have been an author of books with a different kind of approach in conveying legal knowledge. You're aware of what I mean. So what inspires you to write them?
It's my advocacy, sir. As I mentioned earlier, my advocacy is to make law simple, free from legalistic jargon, to make it simple for the ordinary person so that they can be educated and I can be educated at the same time. What I've learned is that precisely, not only law practitioners are particularly interested in the field of law, even the ordinary persons, especially during times of um, national crisis or even not a crisis of particular interest to the general public during impeachment. And I believe another one is forthcoming. And it is incumbent upon us, practitioners and even juries, to explain the law in a very, very simple manner that they can understand so that they can participate and join.
And does it include uh, the fact that you put into characters superheroes?
Yes, sir, because I was a deprived child and I didn't have much toys given to me when I was a child. But with respect to that, it is part of my advocacy. I think I have the ability to spot the human dimension in a particular issue and reduce it to analogies. And my analogies are superheroes. For example, the problem of a particular couple is basic. And I use my books to tell them, even superheroes, when they are married, like Mrs. Superman, Mrs. Batman, they will experience the same marital problems, even if they have superpowers.
So your field of interest is family law, no? Is it not odd that you are not teaching that subject in law school?
Actually, I am indirectly, sir, because I taught in Ateneo Law and MLQ Court Prac. And the cases I used as basis is nullity of marriage. And during those court practice sessions of mine, I didn't use the students as the actors. I used real life psychologists like in Ateneo and MLQU, the very well-known Nelly Tayag usually appears in my court practice sessions. And I have a particular case that she acts out, but she's very experienced. So the kids would ask them questions as if they're already lawyers and they're asking a real psychologist and the person that made Ms. Neditayag. So it's not accurate to say that I don't practice family law in my teaching because during the first half of court prac, it is actually nullity of marriage, and I use that particular occasion to expound on the different doctrines of family law.
So I would like to take advantage of this interview, no, to learn from your field of interest. So for instance, a certain person by the name of Oni, no, went missing. The present spouse, of course, filed a case for the declaration of presumptive death, okay, for the purpose of contracting a marriage. So after quite a while, no, probably years, this certain Oni reappeared but did not file an affidavit of reappearance. Instead, he went to marry his childhood sweetheart by the name of Inday. So what is the status of that marriage of Oni and Inday?
The reappeared person is me, and I remarried without...
I did not say you. It's Oni.
Yeah, Oni. I'm Oni kasi. Sorry. I disabused myself from being such. Okay. Oni got married again without filing the
Because
affidavit.
diba, we know that
Yes.
the affidavit of reappearance would technically void the marriage of the
First.
present spouse. Diba? At saka yung kanyang, let's say, Anton, the another guy. So instead of filing this affidavit of reappearance,
He remarried.
he remarried. He did not file, thereby not invalidating the marriage of the present spouse and Anton. Now, sabi niya, wow, you are now married, you are happily married, you have a good love life, good heart. I also want to have a good heart.
So what is the status?
Maybe this Oni is very wise. Diba? He knows how to circumvent the law.
He's not wise, sir, because if you're married twice, you have two sets of in-laws. So he's not wise. At any rate, I think the question is what is the status of the marriage?
Age of Oni and Inday.
I think it is valid until annulled and voided. And under Article 42 of the Civil Code, I think it's the applicable provision. It's valid. Whoever files for annulity of the subsequent marriage, be it the first wife or even the second wife, if she feels that her marriage now is bigamous, considering there are two Mrs. Onis, it must be annulled to the courts, and she must have the burden of proof of proving that it is indeed bigamous, and non-filing of the affidavit of reappearance would be crucial. And the mere fact that is not filed, the affidavit was not filed immediately, would not automatically cause the nullity of the second marriage, but it has to go to the courts.
So purposes of filing a criminal case, is the present spouse considered as an offended spouse?
For purposes of filing for some bigamy, yes, sir. If she feels that
So she will have two marriages now.
That's why. That's that's why she is filing for a criminal case of bigamy, I suppose, because of the basis of the two marriages. So she's the offended spouse.
But she's married to another guy. So how
Siya
can-
ba yung married?
diba? This present spouse, contracted a second marriage, diba? With Anton. Now, can she, no? The present spouse filed a case, no, against Oni, probably criminally, for concubinage.
Concubinage.
Is she an offended spouse, no, within the purview of our criminal law? Or can she file, no, as you want, no, to venture into this civil aspect? Can she file a case for the declaration of nullity of marriage because, no, I am the offended spouse, and the marriage contracted by the present spouse with Anton is bigamous?
I think she can. I'm using analogous case of Resio versus Garcia in relation to a petition for recognition divorce, where there are another subsequent marriage, and the second spouse at that time didn't know for a fact that her husband was married to an Australian citizen. So using that as analogy, because I'm not entirely sure, to be honest, but using that as an analogy, I think she can file a petition for declaration of nullity based on the fact that it's bigamous. However, the validity of that second or even the first marriage must be established first. So using that case of Resio versus Garcia as a backdrop, I think she can. I may be wrong, sir, but
Yeah. So it would happen that this girl, this present spouse would have, if according to this case is granted, petitions granted, would have two spouses. Oni and Anton. Because what she filed is the declaration, diba, of the nullity of Oni's marriage to Inday.
I thought it was her marriage to Anton or to Oni.
No, she didn't file anything about that. No, because what would declare it valid is simply the reappearance, no,
Yeah.
the affidavit.
I'm confused. Honestly.
Maybe because the party involved is Oni.
Yes, sir. Maybe if you had a different subject.
How
But
about how about
still
if
to venture a guess. Anyway.
how about if the person involved is Karl? To
If
be sure
it will
that-
end up with the second spouse, the present spouse having two wives, of course that's not allowable. But as I mentioned, if she wants to file a case to annul the first marriage,
Oh.
it can be done because it is presumed valid until it is annulled by the courts.
any rate, we all agree, but because there is an absence of law on that.
May absence pala.
There is no provision of law. No? What the family code only provides that the remedy, no, to nullify, no, the second marriage is the mere filing of the affidavit of reappearance. No? But it did not contemplate a situation wherein, no, the missing spouse, the reappearing spouse, would now contract another marriage. There is no.
But if I was Oni, it would not reappear, sir.
Okay. So you also, I was reading your profile. You lectured on the dilemma of judges in handling drug-related criminal cases. So can you tell us what was the synopsis of your lecture there?
Drug cases are high profile, and the dilemma I faced at that particular time when I was a regional trial court judge, they approach from all angles, whether you know them or you don't know them, through a friend or whatever. That's the dilemma we face, or I faced. And the challenges is to separate yourselves from those influencers. But it will take a toll on you regardless of whether you ignore them or not. Because drug cases are, and I point to the particular experience of Judge Fortel Rosales of Tingloy, Batangas, who was assassinated, and he ignored the overtures, but yet he was assassinated. So he's a friend of mine in the OSG, and it had a particular impact on me, especially when I was promoted to the RTC. And that's the dilemma I was talking about, because whether we ignore it or not, somehow it puts our life in danger. It somehow even affects the way we handle and dispose cases.
So do you think you're familiar with the case of the Montiero, People vs. Montero? Did it somehow address the dilemma that you were that confronted you?
I'm sorry, sir. I'm not familiar with that case. Maybe I'll be enlightened
About
first.
the guidelines regarding the plea bargaining in
Plea bargaining.
in the drugs cases. Did it somehow address
Yes,
the
sir.
challenges, the
Definitely.
dilemma?
It somehow erased or negated the subjective aspect of deciding a case based on judge's discretion. It can in a way be plea bargained and all parties consent. Then it will be to the advantage to the juror or the judge and even the accused. So as far as guidelines are concerned, I'm very much in favor of plea bargaining.
Yeah. Okay. You mentioned earlier, Justice, about the writ of amparo. You know that there are only 3 grounds provided for by the administrative matter, by the Supreme Court rules. So why do you think it is confined to just 3 grounds for the issuance of the writ of amparo?
As I mentioned, writ of amparo cases are very hard to prove as far as the petitioners are concerned. It is always decided on the basis of totality of evidence as ruled in Razon versus Taquidis. So why there are only 3 grounds? Because the more grounds you have, at the end of the day,
Diba, Justice, the grounds are the number 1, extrajudicial killing, and forced disappearance. Number 2, and number 3 is the threat thereof. So why is it limited? When in fact, no, sabi mo nga, we just borrowed this concept from the other country, and the other country interpreted this writ of amparo as a writ in order to protect the constitutional rights of the parties. There are several constitutional rights which can be protected by the writ of amparo. Why did we limit it into 3?
precisely because it can be abused, as I've said. In the earlier case that was mentioned, the Harry Roque case, whereby he filed a writ of amparo because of in reaction to the threat of his incarceration by the Congress. In that particular example, it goes to show if it is not limited to strict disappearances and threat to life, then even a learned practitioner such as the then spokesman Harry Roque would have used it and for its improper utilization. So what more other practitioners? So I think limiting it to those three restrictions is all the more proper.
So you would not advocate for the inclusion of other constitutional rights, no, in the event you are appointed, no, in the Supreme Court.
Yes, sir. As it is, the way we handle amparo cases is very much convoluted, and either party has a chance of proving their case, and it's up to us, justice, to pick whoever is who better presented their case, and either way could be ruled. So as far as the simplest form of writ of amparo, I'm not in favor of broadening the issues of writ of amparo cases.
So I understand you were around 11 years in the OSG. Have
Yes,
you
sir.
handled land registration cases?
With particular urgency.
Yes. No. So this is the case. No. For instance, no, a petition. You're familiar with the petition for confirmation of imperfect titles, which
Yes.
simply means titling. No? So there, a petition was filed for the confirmation of an imperfect title. No? It was the petition was denied by the RTC on the ground that, diba, if you recall, no, on the basis of the PD 29, it says that, no, those who by themselves or their predecessors in interest have been in open, continuous, exclusive, notorious possession and occupation of a alienable and disposable land under the bona fide claim of ownership since June 12, 1945. On the basis of that, the petition was denied. Now, it is appealed to the CA. Now, the CA, during the pendency of this appeal, this new law took into effect, which says now that removing that portion of since June 12, 1945 into 20 years, yung acquisitive prescription. Now, do you think the law, that new law, should be given retroactive effect so that the petition would be granted?
The 20-year prescriptive period be retroactively applied.
It's RA 11573. It's actual law, no? Making it much easier to confirm an imperfect title.
Yes.
Should
However,
it be given a retroactive effect?
I don't think so, sir, because land registration cases and land registration laws are convoluted to begin with, and it's very much prone to abuse, especially by syndicates who have the temerity to double sale and fake titles. If we become lenient and apply this retroactively, so much more will these personalities be more prone to abuse of such privilege. As it is, the 1945 rule is a well-clad limitation in itself. The mere fact that it was reduced can be abused all the more, and even if it be abused all the more if it is given retroactive effect.
Interestingly, the Supreme Court said otherwise. No? It can be given. Interesting. It can be given a retroactive effect.
Yes, but I was asked for my opinion, sir.
Yeah, it's good, no, because I understand, no, this is something new that I even myself, no, member of the Academy, was surprised teaching the subject of land titles and deeds. No. Another one, no, with respect to the retroactive application of law. No, for instance, in election law, for instance, a person was, no, during an barangay election period, no, person was caught, no, in possession of a firearm. So prosecution filed a case for violation of the COMELEC's gun ban. No? So while the case is pending, no, the new law was, or a day after he was caught, a new law took into effect, which is postponing the barangay election. Thus, the accused filed a case for the quashal of the information. So do you think, no, this law, no, kasi sabi natin, di ba, yung penal laws, if they are
Beneficial.
beneficial to the accused, can be given. So the question before the Supreme Court is, can this be considered as a penal law? The law that postpones, no, the barangay election, can it be treated, no, as a criminal law that will give, no, that will be given a retroactive effect so as to benefit the accused in that case?
I think the penal law we're talking about is the gun ban
Mhm.
possession. So the curative law now is the postponement
Yes, the law.
of the barangay elections. Regardless of the nature of the subsequent law, if it is beneficial to the accused, as I mentioned, regardless of the nomenclature of this, the nature of the subsequent law, if it will benefit the accused, I think it must be
Yeah.
under our criminal statutes applied to the accused
Yeah.
with this particular problem.
So interesting case, no? It's given retroactive even if it is not technically
A criminal law.
a penal law. Yeah. So in another case, Justice, no, it's very peculiar that the Supreme Court was not able to declare the law unconstitutional because of the 7-7 voting. And for a law to be declared unconstitutional, it requires 8-7. No, but at that time, there were only 14 members of the Supreme Court, 7-7. And I'm referring to the case of IPRA, no, or the law IPRA. So the petitioners there, Sagani Cruz, filed for the declaration of the unconstitutionality of some of its provisions, saying that, no, you are giving the
Land.
IPs,
Land.
no, to the and violative of our Regalian doctrine, and no, they are given, no, the right to exploit, develop, utilize the natural resources found therein. Again, violative of the Regalian doctrine. Now you will be
15.
assuming the case is still pending.
I
You
will
are
be
the 15th member of the Supreme Court. Which side are you going to take? That of the IPs, no, saying that, no, we are entitled to this land by virtue of native title, or are you going to take the side of the state, no, by virtue of this Regalian doctrine?
Without batting an eyelash, sir, I will take the side of the indigenous people. As I mentioned, I have always been with the predisposition of spotting or determining the human dimension of particular issue or problem. And in this case, that is practical example of what my bias are. And the indigenous people, even in other countries, they favor, for example, in America, the Indians, di ba, the Aborigines in Australia, they are given certain advantages in terms of land acquisition. And given that premise and backdrop, I don't see any problem why, being a 15th member, I will do the same with respect to the indigenous people, sir.
Last question, Justice. So I ask this to all applicants. So one of the barometers for our global competitiveness is the rule of law index. You may be familiar with that concept, no? So one of the concrete, or one of the keys to achieve this global competitiveness through this rule of law index is adherence to good governance. So if appointed as an Associate Justice of the Supreme Court, so what would be your concrete plans, no, particularly involving the principle of accountability, no, in order to attain the objective of increasing our standing in this rule of law index?
In relation to my potential or probable job in the Supreme Court. Right now, sir, I was tasked by the Committee on Gender to craft a position paper on the male population in the judiciary responding to the problem of VAUSI. And in that position paper, I crafted and submitted just recently to the Committee on Gender. I proposed a more evidence-based approach, because already there's a existing organization movement opposing violence against women everywhere. But practically, it just entails trainings and workshops for the male population. As far as good governance is concerned, on the part of judiciary is concerned, I would call for a more inclusive and gender-based approach towards responding to the problem of VAUSI. And with respect to the evidence-based approach, we must conduct surveys of how our mindsets as male population members of the judiciary are concerned. We must respond as far as our trainings or programs are concerned in relation to this mindset of ours. My personal experience is when I was an RTC judge, a staff of mine, female staff, was abused by her husband, who is a judicial employee in a different sala. I would have wanted to address the problem myself, but if I did so, I would not be applying now. Maybe I would have disqualified. However, with respect to that problem, I believe that the judiciary must walk the talk, especially in terms of governance and inclusivity. We must make sure that these violators, male violators within the judiciary, are addressed to, and it starts with proper survey, proper determination of our mindsets, being male members of the judiciary.
Thank you, Justice. That will be all.
Thank you, sir.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marife. Good morning, Justice.
Morning, sir.
We interviewed you before, but I forgot the questions. What did I cover then?
Warrantless arrest, sapla, saluday, and I was not able to cite a particular case within sapla. And immediately after the
Also
interview,
Sapla
I
and
researched it.
Saluday.
Cochlane case.
But now I will not ask you
That's why.
those cases.
That's why I wanted to air it.
Considering that I represent the retired justices, I will first ask the questions they suggested. Okay. I will start first with question of Justice Ascuna. Number one, in what ways have your present position prepared you to be fit for the Supreme Court? You answered that briefly. You covered that briefly earlier. You can add if you want to say.
And just want to say that I'm very thankful on the realization that judiciary work is not merely adjudicatory. It's essentially committee work and administrative. Even the administrative aspect is some small part. The committee work, which I'm now involved in, pretty much enlightened me to the scope of a jurist in general.
Thank you. Question number two, what should the Supreme Court be doing differently and why?
Right now, I think already answered partly as far as if appointed, should I endeavor to add or improve on. It's with respect to certain programs of the judiciary or even the programs in SPJI. If they are effective to begin with, and it can only be done by a proper unit that can be created within the Supreme Court. Right now, I know for a fact that the Office of the Court Administrator has tons of data available. And from there, the problem is how to analyze the data, how to evaluate the data, if there's this data in relation to the programs being implemented are responsive to the very issues they want to address, and hopefully learn from the evaluation. So if I'm going to hopefully, fortunately, appointed, I would opt and bat for the creation of a unit that would be staffed by statisticians who would analyze the data because it cannot be done by ordinary mortals and analyze the output of all regular courts and interpret this data and propose improvements of certain programs.
Thank you. That was the last question of Justice Ascuna. Now, from Justice Brion, was he your professor in
No, sir.
Ateneo? No. This is his question. Is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why, and explain fully.
The Chief Justice individually, sir?
Is it legally correct to say that our Chief Justice has a more, maybe this is in general, not just Chief Justice, Esmundo in particular, has a more profound influence on law than our President has?
That's why, sir, I ask if it is on the basis of the Chief Justice alone acting or in his capacity of the Chief Justice per se, departed from the other Justice of the Supreme Court, then I would have to answer in the negative. Because the Chief Justice alone, he's just a co-equal from the other members of the Supreme Court. Now, if it is the Chief Justice acting or on behalf of the other members of the Supreme Court, en banc, to be more precise, then I will have to say, yes, the Chief Justice in relation to the office he holds in addition to the other members of the Supreme Court. He is more learned, more capacitated to say something about the law, interpret the law, and convey this particular law, any law for that matter, in relation to the President. But acting alone, I don't think so, sir.
Question number 2. Is there a difference between strict scrutiny and strict construction?
Strict
He was
scrutiny
referring
and strict
to,
construction.
Interpretation of statutes, Justice Brion.
Strict scrutiny test, I guess that is the
Is there a
basis.
difference between strict scrutiny and strict construction?
The test, I'm particularly, I experienced that, I learned that strict scrutiny in the case of,
Recall Estrada versus Sandigan Bayan.
and even Mordilejos yata yun, Mordilejos case about transcendental importance and facial challenge, where the church complained about tabloids. I think that was where the strict scrutiny test was applied, and the rational basis test as the first test, and the immediate scrutiny test. But that was the only phrase that I came across about strict scrutiny test. So the question is, sir, is it more? What is the question, sir?
Is there a difference between strict scrutiny and strict construction?
That's why, given those three enumerations of the tests I encountered, there's no mention about strict construction. I would surmise that the scrutiny came about precisely because of the interpretation brought about by the construction of the statute. So I don't think, if I will venture an answer, I think there's no difference.
No difference. Okay. Explain fully the concept of protected speech and unprotected speech.
Protected speech,
Taken from your book, Ateneo, Dean Bernas, Father Bernas, by Justice Brion.
protected speech and unprotected speech by its nomenclature presupposes that any utterance, remark, or sentence for that matter is protected if it is in the confines of such or environment of the speech, is that you can never, one person transgressed by such speech can never file any case in relation to that speech that is protected. But unprotected speech outside the confines of an environment, let's say of Congress, for example, if uttered, spoken, or mentioned, given this unprotected environment, then any person who seeks redress as a result of being injured or damaged can do so precisely because of that speech or utterance was unprotected speech.
That was the last question. This is from Justice Abad, Manadera Atenean. What rule governs the interpretation of laws when applied to actual cases?
Rule.
What rule?
I forgot the term for the rule, but I know for a fact that guidelines to apply those rules, it must be just, it must be open, based on open governance, and just open governance, accountable and impartial justice. And the last, it escapes me. But I don't know the term, sir. I'm sorry. What do you call that term?
It's okay lang. Oh. Well, he suggested the answer. You just applied the literal meaning of the law, textual, unless this will result in patent injustice. This
Yes, sir.
answer. So, question number 2. What area of the law do you feel you can immensely contribute to in its development?
Area of the law, my particular interest, I mentioned, is family law. And given the chance, I would like to share my interest once appointed in the Supreme Court in the area of family law, particularly Article 36 of the Family Code and petitions for recognition of foreign divorce.
Okay, thank you. The next set of questions come from Justice Tiam. Now, number 1, would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cybercrimes based on procedural grounds? Explain your answer. If the answer is yes, can you give examples of such procedural grounds which you think are reasonable grounds for acquittal?
Would I consider acquitting accused persons charged of a particular crime of heinous nature based on procedural grounds? I think, yes, sir, primarily because the converse of it is that certain accused can be convicted based on procedural grounds, or his failure to file a motion to quash, for example, in the case of People versus Gomez, where he was charged for murder and the information was defective. He was nonetheless convicted of homicide. He could have otherwise been acquitted had he filed a motion to quash. The ruling of the Supreme Court there was the conviction was proper because he precisely failed to file a motion to quash. And it's a procedural ground by which he was convicted. The question now is, I'm answering it in the converse. With the same reason and with the same breath, I will consider acquitting an accused based on procedural grounds also, because it is only fair. If an accused can be convicted based on procedural grounds, with the same manner and nature, he can also be acquitted.
Okay, thank you. Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently?
in the threat of being
Yeah, we will not take it against you.
you, sir, but the justices to the Supreme Court, Matt. But just the same, as I said, I'm not fearful of addressing this, even on an aspect of friendly banter with them. Recently, the case of Republic versus Nang, whereby it was decided by Justice Di Mampao, and that is my bone of contention with respect to petitions for recognition of foreign divorce, particularly divorce by agreement. He mentioned in this particular case of Republic versus Nang that divorce by agreement does not violate Article 17 on the issue of collusion. I am under the impression that divorce by agreements are essentially collusionary. Justice Di Mampao ruled or explained that collusion is different from an agreement. There's nothing secretive about it when it comes to agreements or divorce by agreement. How about with respect to collusion, there's somehow the secret aspect of it. I submit there's no distinction. If it's an agreement, whether it's secret or not, it's collusionary. And that is my second article precisely that is mentioned in my third book. But petition, I basically agree with Justice Kagiwa's dissenting opinion in Republic versus Manalo that divorce in particular has given, petition for divorce in Republic versus Manalo has given blanket authority in the recognition of divorce obtained by the spouses. All the more it resonates in divorce by agreement. And this is specifically true in Japanese divorce by agreement, which is what popular right now.
If you
So-
agree with Justice Kagiwa, you disagree.
No, I don't agree with Justice. I agree with his statement that
I see.
it gives blanket authority.
Oh.
And it resonates all the more because he mentioned in his dissenting in Republic versus Manalo that there was judicial legislation that is dissenting. I don't agree there was judicial legislation because obtained is a broad term and its literal application can apply to a Filipino spouse obtaining it, not necessarily filing it. But I agree with his opinion in his dissent that it gives blanket recognition for divorce by agreement. And somehow it is best exemplified in this Republic versus Nang. Because even divorce by agreement now is being given blanket recognition despite the fact it violates Article 17 of the Civil Code, that it is essentially collusionary. And if given the chance, sir, I would espouse that this be revisited, this Republic versus Nang. And I note that Justice Hernando and Justice Singh expressed their dissenting opinions, I echoed their dissenting opinion that there's no distinction between an agreement and collusion. It's basically collusionary.
Thank you. You explained it vehemently.
Yes, sir.
A book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation?
As the most dangerous branch, sir? I don't think so. We're not the most dangerous branch. But if the author speaks about the fact that the judges, the juries in particular, are not accountable, meaning they're not re-elected or appointed by the people at large, and they can, quote-unquote, haphazardly echo their opinions, then I would have to agree that at times we are dangerous in the manner by which we espouse our views, especially in line with the fact that we cannot be re-elected if we're not elected in relation to other branches of government.
Okay. If you know this only, in the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th justice?
In the U.S. Supreme Court, sir?
Yes.
So I presume there's an existing 10th member of the Supreme Court who must naturally be a lawyer.
Yes.
So if I would venture a guess, in relation to the existing governmental setup of the United States, it can either be, being a lawyer, can either be the Secretary of Justice or the Attorney General. So either of the two, but there can only be one 10th member.
Secretary of Justice.
The Department of Justice, if they have a Department of Justice. So I'm only guessing that it must be a lawyer, the 10th member.
Yes.
So if there's a Secretary of Justice, I don't think so. If there's none, then it must be the U.S. Attorney General.
Attorney General. Yes, you came from the OSG. The answer is the U.S. Solicitor General.
50% I got it.
Sa US yun.
Sa
hindi
US
sa
yun.
atin. Oh. Okay, if you know only, what is the doctrine of Rule of Four adopted in the U.S. Supreme Court?
Rule of 4. Noting the fact that the U.S. Supreme Court comprises of 9 justices, I'm making a educated guess, sir. There are 9 justices. So how can there be a rule of 4?
What is the doctrine of Rule of Four?
So if there are 4 in relation to the 5, they're in the minority. So with respect
Have you heard
to...
of it? Have you heard of it?
No, sir. But if I will venture a guess, and I'm adventurous in seeking answers to certain questions. I like to find out myself if I'm wrong or correct. The fact that they are 4 and in the minority, I think they have a right to be heard, especially in relation to the views of the other 5. So if there's going to be a rule that I can educatedly guess myself, is that the right of this, the rule of 4. There's no rule, but as far as their espousing their views are concerned, they have the right to express to do so. I don't know if I got it.
And you can find that out.
Yes,
You're
sir.
a wide reader
Immediately
anyway.
again after this.
When I asked you the cases of Sapla and Saluday, they were new cases. So I will just ask you old cases. Oh. No, you were asked recent about Montiero.
Which I don't know.
You remember the Montiero case where the Supreme Court issued the 9 guidelines for plea bargaining. Do you remember that case?
No, sir. But I remember the guidelines as applied here.
You remember the guidelines. Okay. One of your references is Justice Ami Javier. And she was also from the Office of the Solicitor General.
Yes, sir.
And she dissented. Do you know why she dissented? What is her dissenting opinion in Montiero?
Honestly, sir, I don't know. I'm sorry.
Oh, okay lang. Old. What are the essential elements of freedom of expression?
Essential elements of freedom of expression is that the right to speak on a particular matter must not be broad so as to invade the rights of others and damage others. And it must be confined within the scope of that speech, sir.
There are only 2 essential elements. 1, freedom from previous restraint, and 2, freedom from subsequent punishment. This is an old case. What can you say about the ban on exit polls by the COMELEC?
I think it's constitutional in the sense that persons exiting from the polling precinct should not be bothered. And if it will create a trending effect too early within the election day, then that will be detrimental to the candidates and the electorate as a whole.
You read ABS-CBN versus Comelec, January 28, 2000 case. If you remember, what are the three, what do you call? Nawala. Forget the term. Three inherent powers of the state.
I know that. Eminent domain because I came from the OSG,
Yes.
police power, and taxation.
Correct.
Nakakuha rin ako.
You will also get this. Senior citizens law. What is its basis?
Essentially, humanitarian consideration, sir.
I'll give you just from the three. Just from the
The three powers.
yes, taxation, eminent domain.
Definitely not
Police
eminent
power.
domain.
There is already Supreme Court decision.
Yes, sir.
That's what I'm asking.
Police. It's not police power. And definitely, I think if venture against is taxation because somehow it drill down to income on the part,
Not also eminent domain
not also eminent domain.
because there is no compensation.
If they die soon, sir, they become part of the eminent domain.
So it's not police power.
I don't think it's police power, but
So
it can be because it's
what did the Supreme Court say? What
of
was
course
the
it's
basis?
constitutional, but if the power within these three powers is to be applied, I will amend my answer because it's not taxation because no one is being taxed. So it's got to be police power, the inherent power of the state to craft laws that will benefit the public in general,
Not taxation.
not taxation, sir.
So what
Because the establishments won't even have the benefit of using it to offset taxes, di ba? So,
what is your final answer? Because your
police power, sir.
police power of the Supreme Court agrees with you.
Yes, nakadalawa na ako.
Thank you very much, Justice. Your excuse.
Thank you very much, sir.
Thank you, Justice Mendoza. Thank you, Court of Appeals Associate Justice Ronaldo Roberto Martin. Yes po. Your Honors, the next candidate to be interviewed this morning is the Honorable Sandigan Bayan Associate Justice Karl B. Miranda. Good morning, Justice Miranda.
Ay, good morning po.
The first to interview Justice Miranda is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good morning, Justice Miranda.
Good morning, ma'am.
Is this your first time to apply for the position of Associate Justice of the Supreme Court?
Yes, ma'am.
Oh. And you have been with the Sandigan Bayan for 9 years.
Yes, ma'am, since January 2019.
And then with the Solgen OSG, 28 years, is that correct?
Almost 30 years, ma'am.
Wow.
Almost 30 years. A few months short of 30 years.
In your 9 years as Associate Justice of the Sandigan Bayan, what challenges have you encountered, and if any, and how did you resolve these challenges?
Thank you, ma'am. I would think that the first challenge would be the need to increase the budget of the Sandigan Bayan. Aside from our task of adjudicating cases, we belong to different committees, and as soon as I was appointed to Sandigan Bayan, the Court and Bank asked me to join the Budget Committee. So I found out that the court was not getting the budget that it required to be able to perform its duties and serve the people. Kulang na kulang po yung budget namin noon. So and it affected our operations. And in addition to this, this affected also the benefits that we could give to the court employees.
And how did you address this?
I addressed it, ma'am, the same way that I addressed the budget of the OSG. When I was at the OSG, I was also made head of the budget committee. So we had to deal with the DBM and tell them that we should be given the budget that we really need and not the budget that they will say we can only get because of the limited funds. Kasi sometimes sasabihin nila, oh, hindi kayo pwedeng humingi ng more than 5%, ah. Hindi kayo pwedeng humingi, o kaya wag na kayong humingi kasi kulang ang pera. But that cannot be. That cannot be for the OSG, for the court, or for any government agency. If they are, if these agencies or the court is to be able to perform its duties, then it must be properly funded. Everything I would tell the justices and our employees starts with a budget. Without any budget, hindi ho tatakbo. That's why even when we look at the laws being passed by Congress, there is always a portion there saying this is the budget. Otherwise, it will become another unfunded law na hindi mai-implement. So that was what we did. We sat down with DBM and told them, ito po ang kailangan namin. And if they did not give us what we needed, we would seek a reconsideration, comply with the procedure. And again, if they did not give us what we needed, tapos they come up with the NEP without the budget that we requested, we would go to Congress and look for champions for the Office of the Solicitor General or the Sandigan Bayan who understand the nature of the work that we do. I am sorry to say, ma'am, that we are assigned analysts in the DBM. I know the DBM is really saddled with a lot of work and has to balance dahil sa kulang nga yung budget. But we are assigned analysts who do not know the nature of the work of the courts, who do not know the nature of the work of agencies belonging to the justice sector. So we have to explain to them and then even tell them na hindi nila, like when it comes to the budget of the courts, if they give us this much budget for this year, then they cannot reduce that for the next year. I'm talking of recurring expenses. Of course, pag capital outlay, pwedeng tanggalin yun. Oh, but it's really hard. It's really hard to do.
Have you succeeded
I'd
in
like to
increasing the budget for the Sandigan Bayan?
I would like to think so, ma'am, because when we started, our budget was about 700 million. But I mean, you came from an appellate court too, so I think you will know na how kulang that is. But over the years, up to now, with the cooperation now of the DBM, no, in part they are cooperating. We have increased this to about over 2 billion pesos.
Wow, that's a lot.
Yes, ma'am, but like all courts, we are very conservative in the way that we spend the money entrusted to us and make sure that these are only used for the purpose that Congress has given.
So until now, you're part of the budget committee?
Yes, ma'am. I am. I've been. Yes, I've been. I am
Since your appointment? to
since
the
my appointment. But
Sandigan
now we have a chairperson, this is Justice Ian Jacinto. Magaling sa budget po. And I just co-chair it. But I am part of the Supreme Court Budget Committee. Dahil sa when we prepare the budget for the whole judiciary, there is a coordination meeting.
What other committees do you belong to
Okay,
in the Sandigan Bayan,
okay, yes,
if
ma'am.
any?
It's I was given the task to head the building committee because the Sandigan Bayan's present building, it's about 20 years old, but already has structural integrity issues such that we could not properly use the 5th floor. Oh. So kulang na kulang ho yung office spaces. And for which reason we have to put up a new building. And happily, thank you to the DBM and of course to Congress and the Senate, we were given funding to put up a new building behind the present Sandigan Bayan building. We hope to come up with a new 9-story building on a lot that we are going to lease from the COA. The lot's about half a hectare.
How about any significant case or legal decision you have rendered which had a profound impact on you? Please share your experience, but you need not mention the names of the parties. As a Sandigan Bayan Justice.
Okay, okay, yes, ma'am. Okay, I think one case would be this involves a governor of a province that tried to raise or that raised funding for the province through the issuance of bonds. And then they put up a commercial building, the proceeds of which are supposed to go to the local government to augment its income. In that case, we acquitted the accused governor because we found out that the prosecution failed to prove their case. But why do I find this significant? Kasi po, di ba, unlike sa Supreme Court na pag may decision, di ba, that will be the case that all the courts will have to follow. Sandigan Bayan, siyempre, and then the lower courts, that involves only the parties, di ba? So, sabihin natin, in that case, yung nag-complain, siyempre, the ombudsman versus the governor. Basically, ganun lang. But that case is important to me because there we had to show, we were saying there, and I wrote there in that case that public officials who are given the power and the duty to use this particular power for the good of their constituents should not be afraid to use it. So in this case, raising funding.
What was the charge?
The violation of Republic Act 3019, the Anti-Graft and Corruption Law, because it violated certain procedures in the acquisition of this and that, the construction, you know in charge. But what I wanted to say there also, to all local governments who might be able to read the decision, is that if you are given the power, do not be afraid to use it so long as you use it properly. Kasi po, ang nangyayari ngayon, di ba, um, we have the Mandanas ruling of the Supreme Court dividing the share of the revenues between the national and the local government. But local government cannot just rely on the internal revenue allotment kasi palaging kukulangin po yun. So they are given the power to raise revenue. To explain it, when I tell my kids when they were younger, ano ba yung ginawa ng local government code where this power to raise raise revenue because they have this power comes from? It's like the local government code gave all local governments from barangays to up to cities, municipalities, and provinces a big generator. You generate power, di ba? You raise funding. We give you a big generator, but we give you one bombilya. Now, it's up to you to use this power to add more bulbs so that you will light up your local government, provide more services to the people, and not just rely on the internal revenue allotment na palaging kukulangin.
May I know what inspired you to apply for the position of Associate Justice?
Okay. I trace my roots, ma'am, part of it, from the Cordilleras. Okay, my great-grandmother was an Igorota from Sagada. And I would remember my grandmother many times when I was young, pointing to the great rice terraces that our ancestors built. And she would tell us stories. Saan galing yung mga bato na yan? Galing doon sa baba, sa river, na kinarga ng ancestors namin paakyat doon sa taas. Or they dug doon sa lupa sa taas, the smaller stones, di ba? Or whatever big building blocks are there. And they put them together because of the scarcity of the stones. Palaging kulang. And every building material, whether it's a big block or a smaller stone, or even the mud that will have to line the walls so that hindi tutulo, maglilik yung rice terraces. Everything is important. Now, I was thinking, building of the rice terraces is no different from nation building. It is no different from trying to help strengthen or build the judiciary. When I look at my qualifications compared to the other great applicants, magagaling po talaga. Yung galing na po dito, and those appointed to the Supreme Court, parang mapapa-atras ako kasi isipin ko, they are the big building blocks. Sila yung titingal ng lupa para hindi mahuhulog. And then yung mga magagaling na iba, mga professors of law na nagtuturo, di ba? They know everything. Sila yung pangpasak doon sa in-between. And me, I feel I'm just like the mud because the only school that I really taught in was the school inside prison, a school for prisoners in Bilibid, not in any law school. Although of late, I was made part of the criminal law department in Philja. So I was thinking, sasali pa ba ako dito? But I said, this application, Your Honors, is not born out of ambition, but rather by the duty of every Filipino to offer himself as a building block to help build our country. The duty of every Filipino lawyer not to aspire for the highest position, although that's normal. Di ba? Sasabihin, bata ka pa lang, gusto mo, dapat Supreme Court ka. It's not that. Not out of ambition, but the duty of every Filipino lawyer to help strengthen and contribute to the building of the Philippine judiciary. Thank you.
In your PDS, it appears that you inhibited in 315 cases. Am I correct?
Yes, ma'am. May I check my records?
Yes. And may I know the grounds for the inhibition?
Yes, ma'am. Okay. Principally, ma'am, most of those cases I inhibited because I handled a related case when I was an assistant solicitor general or solicitor at the office of the solicitor general. As we well know, ma'am, the office of the solicitor general is the lawyer for all government agencies or sued in their officials or sued in their official capacities or sue in such capacity, including that of the office of the ombudsman. So the ombudsman has a lot of cases being handled by the OSG. And we have 30 divisions in the Office of the Solicitor General. We have 331 lawyers, the Solicitor General included in the OSG, so ang dami. So the cases of the Ombudsman used to be spread out to the different divisions. 30 po yung divisions namin. But during my time as an Assistant Solicitor General, Ombudsman Carpio Morales, if I recall correctly, asked that it be centered or be handled by just a few, if I'm not mistaken, 4 divisions for easier coordination. And one of those divisions was the Set Free Ordonez division, which I headed.
Another matter that I noticed in your PDS is that you, please correct me if I'm wrong,
Yes, ma'am.
you have 99 cases that have been undecided within the reglementary period.
Yes, ma'am.
What is the status of the cases now?
They have all been decided. I mean, they have all been filed, ma'am. I thought kasi yung chine-check, yung tinatanong dyan is if I extended beyond the reglementary period. But all of those, we have decided already, ma'am. All of those cases.
So what did it pertain to? You filed extension of time
Yes,
to
ma'am.
resolve,
Yes,
but
ma'am.
all have been acted upon.
Except for one more, I think, in the 6th division.
So this would be after you filed your PDS? Because it's in the PDS. So at the time you submitted your PDS, you still had the 99 cases pending?
No more, ma'am. That because I thought we worked back 5 years. So I included cases where I asked for an extension beyond the period for back to the 5 years, ma'am. Oh. But may I just explain bakit po nakalagay doon 99 cases? The first one, ma'am, was most of those cases was during the pandemic 5 years back. And then as we all know, di ba, there were certain restrictions in our ingress and access to the offices. We could not bring out records too. So necessarily we had to file extensions for that. But almost all of them, no, except for one, I think, is still pending.
All right.
All of them have been
right.
decided except for one.
You are among the references of Justice Martin,
Oh.
who happens also to be an applicant for the same position you're
Yes, ma'am.
applying.
Yes, ma'am.
Between you and Justice Martin, who do you think is the best candidate?
Justice Martin is like the
Between
big.
you and him?
Yes, it's like the big block that I'm saying.
big block of
Yeah,
the
of the
rice
rice
terraces.
terraces. I'm just the mud.
But you're the one that holds the blocks.
No, ma'am. No, ma'am.
In other words,
It's up lang, ma'am, for this august body and the president siguro to decide whether the judiciary needs more building blocks or more putik like myself.
well said.
Thank you, ma'am.
But did you know that he put your name in his PDS, placed your name as one of his...
Several times, ma'am, and
character
I can
references?
attest to the integrity of that person at yung tapang niyan.
But you did not make him one of your character references.
No,
No.
because I was not.
You had other character references.
Yes, ma'am.
Yes.
Yes, ma'am.
Okay. The red light is on, so I will stop there. Good luck to you, Justice.
Thank you, ma'am.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Cuevas. Good afternoon, Justice.
Hi, sir. Good
So
afternoon.
how did you prepare for today's interview?
Okay, I read a lot of cases, trying to remember them, and then of course prayed a lot.
Do you want to know, Justice, the answer of Justice Martin as to who should be appointed in the Supreme Court?
Ano po sabi niya?
Will you endorse him? Will you endorse him?
Yes.
Okay. So if appointed justice, no. By the way, sorry, I have two sets of questions here.
Of course.
One comes from the Secretary of Justice,
Yes, sir.
and one is my own set. Okay, I'll read first the question from the Secretary.
Yes, sir.
Yeah. So here's the first one. You have participated in an international training program on court management at École Nationale de la Magistrature in France.
Mhm.
What specific insights did you gain from this program, and how would you apply them to improve the efficiency of the Supreme Court? Sorry for mispronouncing those foreign words.
Yes, sir. Okay. The biggest insight that I gained there is the importance of technology in speeding up the administration of justice wherever it is to be found. Because as we well know, justice, the administration of justice is not just with the judiciary. We are just part of a justice sector that administers justice. So it starts from the police to the prosecutors to the courts, then to the correctional, and eventually to the community, Your Honor. Every part of this, I call it a pipeline, the justice sector pipeline, will benefit from using technology. Technology is key to advancement, and I think we should not fear it. An example lang po about fearing technology. Many years ago, when I was with the OSG, and we would go to prison to teach, to visit, we saw the problem of prison or jail congestion. And the congestion, Your Honors, is not just because of the inmates, the PDLs there. Talagang congested na if we look at the people there. There was a jail, 600 ang PDLs. Ang restroom, 4 lang. So I could not imagine paano nangyari yun. Congestion is not only because of the PDLs inside, but also because of their visitors, the families coming to visit, the friends coming to see the PDLs, the lawyers trying to assist. So we made the proposal. In my case, I made the proposal to several prison directors on separate occasions, and I asked them, sir, can't we use e-dalaw as an administrative tool, okay, to make the visitation of PDLs easier for the families? Hindi na kailangan magbiyahe from the provinces or those from abroad to visit. Can't we use that? No. At the same time, kasi it will not only make the prison conditions better for the visitors, but also it will be an administrative tool because it will lessen people coming in, and then the possibility, maybe even reducing the incidence of contraband being brought in. Kasi meron at meron nagdadala po ng contraband doon. But every time na even if the prison director says, yes, sige, let's do it, when he will ask his people there, the ones in charge, they would invariably say, ay, hindi po pwede. There's a security concern. Mahirap yan, ganito, ganyan. Yung first 3 na prison directors na kinausap ko, kahit pumayag yung head, the prison director, when it comes to their people, they would say, no, that's mahirap yan. And until the Bureau of Corrections got Director Pangilinan, who was with the Army before. So when I made the proposal, he said yes. And then when he asked his people, the same answer, ay mahirap po yan, security risk, ganito, ganito. And then he told them, hindi ba trabaho nyo nga security, di ayusin nyo. So I was thinking, Your Honors, the resistance to technology sometimes is born out of yung a misunderstanding or a lack of knowledge na paano magamit yan para na it is actually something that can help us. So if I just go fast forward with this e-dalaw, okay, we piloted in the different jails, Manila City Jail, Quezon City Jail, male and female, and the women's correctional. And it helped reduce the number of physical visitors. Sometimes there are poignant stories like, of course, dahil sa limited yung gadgets, visitation time will only be 5 minutes, dapat. But when we launch it in the women's correctional, the line was long. And I was saying, what's holding up the line? And why is that lady still there? Parang 30 minutes na. Hindi pa umaandar. Sabi, hindi pa gumagalaw. Sabi. And then they said, pasensya na ho, kasi that lady PDL gave birth in prison. And when the baby was already a year old, kailangan ibigay sa pamilya. And that kid never knew na her mother was inside prison. She would call and say, oh, she was in Singapore. She'd write a letter, send pictures or whatever. I don't know how she sent them. At ang sinasabi niya, she was in abroad. And that was the first time that they were breaking the story to her. So that entire 30 minutes, she was just crying and crying. Parang ganon. So what I'm saying, Your Honor, is we just have to make them understand that technology is there to help us speed up the administration of justice. Because after e-dalaw, Your Honors, pumasok na, in-expand na ng Bureau of Corrections to e-burol. Because maraming humihingi kung pwedeng lumabas, bumisita, saan hindi pwede, but na-humanize po. Pero the most important, I would say, is the approval of the Supreme Court to have e-hearings, hearings by video conference, because that really help speed up the hearing of cases, not only in our courts but in the lower courts too. It is a great, again, administrative and security feature in hearings, because the so long as the safeguards are implemented, hindi na kailangan ibiyahe yung mga PDLs from jail to the courtroom. Kasi how many personnel will have to accompany again the PDLs? Ilang guards ang kailangan? Sometimes wala silang sasakyan. And then of late, if we remember, there was a vehicle of the BJMP bringing some PDLs to a hearing, tapos a group tried to extract one of the PDLs, and this could have been avoided if e-hearing na lang sana yung ginagamit. Thank you, Your Honor.
So the next question, second question from the Secretary of Justice. Your judicial record shows a high number of inhibitions with 315 cases in which you voluntarily inhibited in the past 5 years. So the question would be, how do you ensure that your inhibitions are based solely on ethical grounds and not due to external pressure or fear of controversy?
Yes, Your Honor. Principally, Your Honors, as I was saying, the inhibitions was born about by my handling of cases of the Ombudsman when I was at the Office of the Solicitor General. While it is true that I have over 300 cases where I inhibited, the reality is, Your Honor, these 360 plus cases are kaya ho siya 360 something, those are the individual informations. But during the hearing itself, they are clustered. Clustered po yun. So in reality, yung 360 plus cases na yun, ang clustered doon is 21 cases. There is one case where there are 194 informations. So right away, hindi ho ganun, pag tinitigyan kasi parang ang laki, di ba? But because they are clustered, if we consider the clustering, I really only inhibited from about 29 cases.
But the question, Justice Doe, is how do you ensure that your inhibitions are based solely on ethical grounds and not due to external pressure or fear of controversy? Perhaps this would pertain if you are now the sitting Associate Justice of the Supreme Court.
Yes, Your Honor. It is due to ethical reasons, because our rules on inhibition and even our rules in inhibition say that if the judge or justice handled the case, then that is mandatory.
So the third question would be, as an Associate Justice of the Sandigan Bayan, you have handled cases involving public officials and high-profile corruption cases.
Yes, Your Honor.
In your view, what is the most significant challenge facing the Philippine judiciary in combating corruption? And how would you address it if ever appointed to the Supreme Court?
Okay. I would think, Your Honor, it would be the education of the public of the need to really fight corruption, of the need to be there when pag kailangan. I am saying this because we have some cases where after the Ombudsman has spent time investigating the case, after the Ombudsman has filed the case with us and then started presenting the evidence, when it comes to their key witness, suddenly, wala na. Oh, wala na. So we don't know if it's politically motivated until para matanggal lang yung or makasuhan. But if they truly want to help clean up or lessen corruption in government, then those who come forward should be there from the start to the finish.
The fourth question, Justice. It can be said that our Constitution shares some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by the U.S. jurisprudence, albeit similarities in the constitutions, in our Constitution?
If so, Your Honor, what
Can you pinpoint to us one particular constitutional, because there is a comparison between our constitution and that of the US. So it says here, can you pinpoint to us particular constitutional principle that you will strictly guard against being influenced by the US jurisprudence despite the similarities between these two constitutions?
Yes, Your Honor. It's, Your Honor, I would say, siguro, one would be the exercise of the court to review the decisions of executive bodies, okay? Because this is given to the judiciary as a duty, not just a power. So, a power we can relinquish, but a duty we cannot. So we cannot. So I think this was put in the Constitution to make sure that the judiciary does not, quote unquote, hide behind the political question doctrine. Wag na natin pakialaman yan. Pag nandun, may grave abuse of discretion amounting to lack of jurisdiction, kailangan tignan natin ng mabuti. Hindi lang pwedeng sasabihin natin, political question yan. It is our duty. Now we cannot give up because that was entrusted to us by the people through the Constitution. Hindi dapat matakot gamitin yung power na yon kasi yan ay pinagkatiwala sa atin.
So the next question, with your long years of practice of law and now as an applicant for a Supreme Court justice position, can you share to us your judicial philosophy?
Judicial philosophy. Being conservative versus a liberal. Your Honor, I would always think that extremes are always not good. Extremes. Of course, there will be times when the law and the evidence dictate that we should take a conservative stand or a liberal stand, then we will have to make the adjustment. So I would say, Your Honor, that maybe I am there more of a conservative in the sense that if there is nothing wrong with the exercise of the power by the executive or the legislature, then we should let it be, unless there are factors that will call us to really look into it. And again, as I am saying, as a duty given to the judiciary, we should not shirk from that responsibility and say it's a political question.
The sixth question, do you have a particular justice here or elsewhere whom you consider an idol and why?
A justice.
Any justice
Okay.
you consider probably
Okay.
a role model or idol?
I've always looked at Chief Justice Jose Abad Santos as a model. He was Secretary of Justice. He was Chief Justice. And later on, acting President of the Philippines and Chief Justice at the same time. And because he did not give in to what the Japanese occupants wanted, he and his son died for that. He is a justice who not only served our country through yung decisions, rendering decisions and administering the judiciary as Chief Justice, but someone who died for our people. And all, ayun, yun po.
Yeah, go ahead, go ahead. Anything else? Oh, that's
No,
good.
no, I didn't want to say he was an Upsilonian too. No, but Your Honors, also because Chief Justice Jose Abad Santos was a champion of fiscal autonomy for the judiciary, and he fought for it, such that Congress would not be able to reduce the salaries of judges and justices.
Okay. Seventh, assuming you were appointed to Supreme Court and given I believe that it's the long number of years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
Okay. Your Honors, I'm 67 years old. So
So probably short.
in case,
Short period.
yun na nga, sasabihin ng iba, baka, ba't ang iksi or what? But Your Honor, what I want to say is that I have been serving in the Supreme Court for so long already, not as Justice of the Supreme Court, but as part of the many committees to which I was appointed by the justices. So one would be the my work at the Justice Sector Coordinating Council, where I am head of the Data Reconciliation Committee for all the justice sector agencies, from the police to the DOJ to the courts to the correction and to community. So what I am saying is that I intend to continue, maybe in an enhanced capacity now, assume if I will be blessed to be appointed to the Supreme Court, to continue our work there. Kasi, Your Honors, the Justice Sector Coordinating Council has done so much to speed up the administration of justice in this country, to improve the administration of justice in this country, because its approach is a sectoral approach. Dati kasi sasabihin, hiwalay, DOJ, problema niya, ano to, police, anong problema, ganito. Di ba? The Justice Sector Coordinating Council, headed by the Chief Justice and together with the Secretary of Justice and the Secretary of the DILG, come together and try to solve common problems of the sector. For example, Your Honor, if you will allow me, example na lang, why are there so many archive cases in the judiciary? It's because when we studied it, nung tinignan ko, saan galing to, bakit ganyan? We found out that for the past 10 years, do you know how many unserved warrants of arrest by the PNPR? Some will say, 5,000, 10,000. No, it's 480,000. 480,000 unserved warrants of arrest. And for the last of that 10 years, I think that's yung 2023, 58,000 po yun. Those, because hindi na-serve yung warrant, the case will remain in our dockets. And for example, sa Sandigan Bayan, in a case for violation 3019, the anti-graft law, nahuli na yung iba, na-try na namin, na-convict or na-acquit, and yet naka-archive yung kaso as far as those who have not been apprehended. So in the records of the judiciary, nakabitin pa rin. And that's why the public will say, tagal naman sa judiciary, ganito. When actually, it is not only us. Hindi ba? Oh. And that's why for this reason, Your Honor, di ba, as part of my work in the Justice Sector Coordinating Council and in the subcommittee in the revision of the rules of court, we recommended an amendment to when it comes to yung warrants of arrest. So dati kasi susundin lang, can you find the accused in this address? Pag wala na, di ba? Now we are recommending na, oh, you serve that 3 times. You detail what efforts were taken to serve the warrants. That's just one part of it, Your Honor. Well, I do hope, if I am lucky enough to be appointed, to continue in that role, helping the Justice Sector Coordinating Council fix the problems so that justice will run faster.
So the next question, 8. In the context of criminal law, how do you reconcile the principle of nullum crimen sine lege, or no crime without law, with the evolving nature of crimes in digital age, such as cyber crimes and artificial intelligence-assisted offenses? So should the judiciary have the power to recognize new crimes absent the explicit legislative provisions?
Thank you for that, Your Honor. In the revised penal code, I think that's Article 5, it says there that if the judge feels that a crime, something that has to, that may ginawang mali, di ba? But there is no law punishing it. It is the duty of the judge to write to the Secretary of Justice so that matter can be brought to the Executive Secretary for informing them of the need for Congress to pass a law to address that. So I think that is one way where the judiciary can help.
Okay. The 9th question, the principle of proportionality requires that the punishment must fit the crime. So how do you view the constitutionality of mandatory minimum sentences, which thereby limit judicial discretion? So the follow-up question would be, should the judiciary have the authority to invalidate such laws if they lead to unjust results?
Again, Your Honor, I think siguro that can be part of what the judiciary can do sa Section 5 of the revised penal code. But I'd like to say, I do agree with that. You know, sometimes, Your Honor, in our courts, kasi yung kaso ngayon, nangyari noon, late lang final yung kaso, and now dinicide namin. And we follow, again, the law and the evidence in deciding how to resolve the case. Ako, honestly, I find myself, when we convict, lalo na kasi nahuli, matanda na yung mga tao, di ba? I find myself praying for for the accused to be convicted. Kasi iniisip ko, in their old age, they will have to raise money for bail while their case is pending appeal. In their old age, alimbawa, in-affirm, tapos may sentence na ganun. I cannot, but there is nothing we can do. We will have to follow the law and maybe just make the recommendations.
The last question from the SOJ. In your view, does the doctrine of presumption of innocence extend beyond the trial stage to public perception and media coverage? How should the judiciary protect the presumption of innocence in an era of widespread media sensationalism?
Okay. Thank you, Your Honor. There have been a series of decisions by the Supreme Court on the matter of contempt. And one of those, one of the speeches regulated, subject, what do you call this? Subject of that would be online speech. Because online speech has to be responsible, especially considering its wide reach, its easy reach, its possibility to go viral. So, in the Lorraine Badoy case, if I'm not mistaken, the Supreme Court cited her in contempt for language inciting the public to against Judge Malagar. She was saying something like it resulted into a threat. So the Supreme Court found her guilty of contempt, indirect contempt, and sentenced her accordingly. But what we did, Your Honors, on our part, and again, and this is because I am part of the subcommittee on the revision of the rules on civil procedure, in particular special civil actions, we made a proposal to include as a new section in the rule of contempt not indirect, not contempt of court, but a more serious form of contempt of court. And this is the contempt of the judiciary. When there is, when such words threaten harm to any member of the court, whether the justice, I mean the judge, the justice, the lawyers, court officials, this can be subject of contempt of the judiciary, and it's only the Supreme Court who can punish this. Although Supreme Court can deputize the or ask the Court of Appeals to hear the case for it. And then the punishment will be much, much higher. It can, we didn't put an amount because ngayon, thousands of pesos lang or what. This one, there is no limit. And then the other proposal there is, in addition to citing the contemnor in contempt and fining or imposing imprisonment or both, the Supreme Court may direct the office of the judiciary marshals to provide protection to the judicial officer concerned and their families.
This is actually a follow-up question on that. I learned from you the contempt of the judiciary. Would that be motu proprio on the part of the, in your proposal, would that be motu proprio on the part of the Supreme Court, or there must be a complaint?
It can be both, Your Honor. It can be through verified petition by someone or the Supreme Court itself.
Okay, so I'll go to my own set of questions, Justice.
Yes, Your Honor.
So if appointed, what would the stakeholders expect from you?
The stakeholders.
Litigants,
Yes, Your Honor.
justices, your colleagues.
Yes, Your Honor. Your Honor, if you will allow me again to answer first by going back to the um, the justice sector, because they are all stakeholders too. So my role, if I do get appointed, and then the Chief Justice assigns me to continue working maybe in an enhanced capacity, working with the Justice Sector Coordinating Council, I will coordinate with all the different members of the justice sector. So from the police, ano yung problema, di ba? Ano yung bakit may backlog dito? Yung nga yung sinasabi po natin earlier, the unserved warrants of arrest. Let's solve that. Let's find a solution to that. Then we go to the prosecution. But happily, the Secretary of Justice has come up with orders before to the prosecution, saying that, to the prosecutors, saying that to make sure that only strong informations or cases are filed, so there will be more or less a certainty of conviction, or review what has been filed and withdraw yung mga informations na weak, because this again can help solve declogging the cases that are archived. Because kung halimbawa, ilang taon na yan, 10 taon, 20 years, naka-archive pa din. The prosecutors can come in and say, wala na yung witnesses, wala na yung ano. So we can properly dispose of those cases. And then when it comes to the courts, Your Honor, if the Supreme Court, the bank will allow me to help in a way, in whatever way we can increase the budget of the judiciary. Because, Your Honors, we are the third branch of government, the judiciary, and yet we only get 1% of the entire budget of the country. 68 trillion or 6 point something trillion ang budget natin, and the judiciary only gets 68 billion. If you will look at the budgets of the other executive departments, mas mataas ang budget sa judiciary. Kulang na kulang po. And I would say the reason for this is the misunderstanding maybe of the public, of other government agencies, of the work that we do. This is what I again want to do. Help inform the public, help inform government agencies. Ano ba yung kino-contribute ng judiciary to the economy, to nation building? Many years ago, Your Honors, when I think we worked with this with Attorney Teddy Te when he was still here, we helped revise the way that we reported in our annual report. Because previously, most of our reports were text-based. Puro reports. Yung mga text. This case, like this, like that. So we said, based on our experience with Congress, when we sit down asking for a budget and this, we put this together. So we listed down ano ba yung mga tinatanong nila. Because, Your Honors, maybe DBM and maybe Congress looks at us as a cost center. Ang judiciary, panggastos lang yan, di ba? O may away kasi ganyan. Not an income-generating part of government, which is totally untrue. Without the courts, this national government infrastructure projects, Your Honor, will not happen. because the courts are the ones resolving the expropriation cases. Na, and these national government infrastructure projects cost billions, maybe even trillions. So we changed the way that we reported our annual report. So we included their cases with economic impact para makita nila, ma'am, during your time, we changed the way that the CTA reported its achievements. So ang ginawa doon is, dati kasi sabihin, this case, this case, this case. No, now, what we show would be how much was resolved by the CTA in favor of government, 7 billion. How much was resolved in favor of the taxpayer? This much. So the public and government officials will have a clear understanding of what the judiciary is doing, bringing in funding to government. It's not only that, commercial cases, environmental cases, and so forth and so on. The judiciary is doing so much, Your Honor, and that, I think, is key for us to be able to get a bigger budget. Thank you.
So next question, Justice. In your PDS, you enlisted one of the cases filed against you is the violation of the SSS law,
Yes.
which of course this complaint was eventually withdrawn.
Yes, Your Honor.
So is it in connection with your bookstore?
No, not the bookstore, Your
Okay.
Honor. Not the bookstore. My wife and I, in the 90s, we had a small company that sold sweet corn on the cob. No, sweet corn on the cob. And then, naabutan ng, if I remember correctly, Asian financial crisis. And we were in the malls kasi po such that bumaba yung sales, mataas ang rental, di ba? And siguro yung pagkukulang ko lang doon was, I asked my wife na kahit yung mga iba nagsarado na or binawasan nila yung tao nila, I said, kung pwede, let's hold on to our people as long as possible, di ba? Because marami dyan nagpapaaral, di ba? And then somewhere, somehow, siguro, the accountant nakaligtaan na, you know. So, yun lang po yun.
What was the reason for the withdrawal?
Because it was
Settlement.
settled.
Oh, yeah,
Oo.
okay. So, in one of your speeches, Justice, you were quoted saying that the CIPRA holds them to a higher standard of conduct in and out of the courtroom as the Bible for all lawyers and a compass that would direct them towards moral and just conduct. So the question would be, is there an interplay between morality and legality?
Morality and legality.
Or are there laws here in the Philippines which is legal but not moral?
Yes, Your Honor. Maybe, okay. Okay. In a recent disbarment case, if I remember, Attorney Aurelio and Yao versus Aurelio, okay, the Supreme Court said that our basis for these cases would be, our guiding principle should be secular. So that's legal, I would think, versus moral. Di ba? So, and not, I mean, versus religious. Oh, and sometimes, morality is tied up with something religious parang ganon. Such that, I remember in another case, there was a teacher who had a child with a boyfriend, but they were not, and they were not married, but there was nothing to prevent them from getting married. and the school removed her. But the Supreme Court said, no, you cannot do that because yun nga po, our guiding principle when it comes to that would be secular and objective, not moral, not religious.
Next question is, in one report, Justice, it was mentioned that Sandigan Associate Justice Karl Miranda urges law enforcers to focus on the quality of arrests instead of the quantity to help decongest prison facilities. He noted that 123 drug prisoners, or out of that 123 prisoners, only 107 or less than 1% were charged for manufacturing. So, question would be, what do you mean by this quality of arrest?
Yes, Your Honor. Your Honor, even as an Assistant Solicitor General, we've handled so many cases where the drugs seized from the accused was very minuscule. Pati yun aabot hanggang Supreme Court. Di ba? And then, if we go to our prisons, most of the cases there, up to now, are drug cases. And when you check, anong klaseng drug case yan? User. Pusher na small, di ba? And when I was checking, how come dun sa 100,000 plus na yun, na at that time when I made that, when I was asked about that, these are the ones involved in the small, quote-unquote, small cases, using, di ba, possessing small quantities. But if you look, and I said, nasaan yung mga drug lords, yung mga manufacturers dyan? Out of the 100,000, parang 100 lang yun. Majority are the small cases, quote-unquote small cases. And the effort that the police will use for all of those 100 cases, whether they are the small users or the ones possessing, is the same effort that the police will use in catching a manufacturer. So what I was saying, Your Honor, was that lahat tayo, from the police to the prosecutors to the courts, running around because that's our duty to address this. We're catching raindrops isa-isa, di ba? Instead of us going there, closing the faucet. That was what I meant, Your Honor.
So speaking of arrest, I'll ask you one recent Supreme Court decision. This is what happened. A motorcycle rider entered a one-way street, not knowing that at the end of the street and at the end of that road were police officers
Yes, Your Honor.
and the barangay tanod. So when this motorcycle rider, these police officers and barangay tanod, he made a U-turn. So the police officers noticed that and chased him.
Mm-hmm.
Now, when they were able to get this motorcycle rider, they were able to see a firearm. Now, he was charged with violation of this comprehensive firearm law. Now, he said that he should not be, that firearm, is not is a fruit of a poisonous tree, so to speak, because what he violated, is a mere ordinance, yung one-way street U-turn.
Yes.
So, and therefore, he should be acquitted. And the arrest and the seizure of the firearm is invalid.
Yes.
So now you are the Justice of the Supreme Court. How are you going to view that case?
I would say, Your Honors, that the violation of an ordinance is not sufficient reason for them to for a warrantless arrest unless they see something more than yung umatras lang siya. That cannot be, and I think Uh, that's a recent
Yeah.
Supreme Court
Yes,
decision
yes.
too.
Yeah.
Yes.
Another report says, Justice, that a Sandigan Bayan Associate Justice hope the lower bail, no, to poor criminals would work and be implemented so the country's jails would be decongested.
Yes,
no?
Your Honor.
So the report says Sandigan Bayan Associate Justice Karl Miranda said congestion of jails in the Philippines already reached an average of 376%, while in some jails, especially here in Metro Manila, this already peaked at 2,700%. So is this idea only pertains to poor criminals?
Uh,
Yung lowering of bail, is this proposal of yours would
Yeah,
only affect poor criminals?
Following, Your Honor, the bail guidelines issued by the Supreme Court, I think by the Department of Justice, I think that benefits mainly those
The poor.
the poor. Oh.
Yeah.
And I'd like to say that's really important, Your Honors, because if you go to our jails now, of course, it has greatly improved the situation in our jails the past 2 years or so has greatly improved in the sense na maraming na-release. It's still very congested but not as congested. Your Honors, I would just want to point out, the Constitution says bawal yung unusual and cruel punishment. But if you put someone in a jail, sabihin na, the regular cells without with ventilation na kulang, di ba? That would I would think already constitute cruel and unusual punishment, lalo na po kung mga senior citizens yun o may sakit. And to think that these people, I'll bifurcate and make a distinction between those already in bilibid and those in jail. In jail, presumed innocent pa yung mga yun kasi many of them, their cases are still being tried. And yet, parang may cruel and unusual punishment na quote-unquote because of the prison condition. Di ba?
My question would be, Justice, so how would you define poor? And why would only give preference to poor insofar as lowering the bail? That idea of yours.
I think, Your Honors, when it comes to defining who is poor or what, maybe we follow the guidelines also of the PAO as to who will be entitled to representation by the PAO. I think that would be a safe guideline.
Another question, Justice. Another report says that former Assistant Solicitor General and incumbent Sandigan Bayan Justice Karl Miranda, whose name was dragged in the controversy hounding the new Bilibid prison, has urged corrections officials to take advantage of public attention and seek more funds for reform. Miranda said his colleagues at the anti-graft court had discouraged him from making a speech at the opening of the 22nd National Correctional Consciousness Week on Monday. So it was quoted saying, some of them, Sandigan Bayan Justices, said, I did not learn from the wrongful criticism by some that arose from our visits to the prison, he said. So now question is, if ever appointed justice to the Supreme Court, would you still continue visiting our jails?
Thank you for that, Your Honor. Yes, Your Honor, if hanggang sa kaya ko, I will go. But let me just explain where yung context of that news report. Because former Secretary Vitaliano Aguirre several years ago showed a film clip about what was happening in prison, and that in that film clip showed me and our OSG legal interns. So I had to say something because sabi unfair naman na i-associate mo kami dun sa drug lords when our stay there was because of our program, because we have at the Office of the Solicitor General, Your Honor, a legal internship program where we ask young law students from all over the country to come and intern at the Office of Solicitor General and see what it is to be a government lawyer. So, and then what we do is we bring them around also to the agencies being represented by the OSG. So it starts from the Office of the it ends with the Office of the President, but it starts with yung prison, so that they can see the conditions, they can see how they can help if they wish to, up to the different agencies, and it ends with the Office of the President. Now, we were there because that was part of the visit. Nagkataon lang, when we got in, they said, oh, you please come into this hall because there is a program. And then someone who they were saying was a drug lord was singing. So parang we just wanted to clarify and make sure na just because we were there doesn't mean to say we tolerate that. Yun lang po.
But now you are the Associate Justice of the Sandigan Bayan, no? Would it again create that impression that you will be meddling with the convicts if ever you go to visit the Bilibid again?
Not at all, Your Honor, because in my I've been going to prison for more than 20 years. I've been teaching in that school. Well, I stopped teaching, but we bring visitors whom we think could help improve the situation there, the facilities and all. But never, you know, if I get to know the women or the men there, I never go beyond their first names. So I do not know what case they are in for. Maybe sometimes at the back of my mind, I'm thinking that maybe I was one of those responsible for sending them there. But I was thinking, we have to come back, Your Honor, because that's the only way na makikita natin kung ano talaga yung nangyayari. And that's why the Supreme Court is even requiring the executive judges to go and visit. Our best example was the Chief Justice himself, Justice Maidas Marquez II, who have gone to Bilibid to see kung ano yung condition. Because kulang na kulang po talaga yung pera for facilities. Thank you.
So, since you are a Sandigan Bayan Associate Justice, you can easily answer a COA case, no? So, can you explain to us the concept of net disallowed amount in COA cases?
Net?
Disallowed amount. Are you familiar with that concept? Yeah, you haven't encountered that?
No.
Yeah. Okay. Sige. Earlier, I heard you, Justice, that you mentioned that the Supreme Court should not veer away, no, from hearing political cases. So,
No, Your Honor. I'm saying it should not shirk from hearing, yes, political cases if the circumstances and the evidence, if the circumstances call for it.
yeah. So the question would be, well, there is now a thin line, no, dividing the doctrine of purposeful hesitation and this expanded power of the Supreme Court, no, to review cases, no, the expanded power of the judicial review. So if there would be, no, equipoise, would you go to hesitate, no, in hearing political cases, or are you going to lean towards the use of the expanded power of judicial review?
Thank you, Your Honor. My answer, Your Honor, is the same. It will depend on the
Yeah, but
circumstances.
it's
but-
equipoise.
But bearing
There's
in mind,
Yeah. There's
Our-
equipoise.
yes,
Parang
yes,
pantay
Your
na
Honor.
pantay.
yung what will make me tilt to one side is the word duty. Duty to hear. It is not just the power. Power we can give up, but our duty to the people we cannot.
At present, Justice, no, informations filed before the Sandigan Bayan, no, they are filed by the OSP, by the Ombudsman.
Yes, sir.
And they still follow this probable cause.
Yes, sir.
Do you think it should be, compared to that of the DOJ, wherein they have increased it to reasonable certainty of conviction?
Your Honor, as I was saying earlier, it's a good thing that the Secretary of Justice came up with that circular. But in all honesty, I am waiting for what the Ombudsman will do in that regard.
Would you know the number of convictions vis-a-vis acquittal
Of
in
this
Sandigan Bayan?
Sandigan Bayan.
Well, at least probably in your division. Or if not in your division, probably in your office.
Of the whole Sandigan Bayan, Your Honor. In 2018, if I'm not mistaken, it's in the 70%, 72, 70, basta ganon. But in
70% acquitted,
conviction.
convicted.
Oo. But in 2022, it has gone down to 26%. Mm-mm. And
Would you know the reasons for well, of course, it's lack of guilt beyond reasonable doubt. But what could be the reason? The evidence were not properly gathered?
Your Honor, I would think one of the reasons would be we have to follow the rulings in Martel. The Martel case. Kasi sabi doon, Martel kasi involved the violation of the procurement law. Okay? But the Supreme Court said there, a mere violation of the procurement law is enough to convict. You go back to 3019, that it must be with manifest partiality, evident bad faith, or gross inexcusable negligence. So, following that, kung wala silang ma-present na evidence of these three, manifest partiality, evident bad faith, and gross inexcusable negligence, we have to acquit. We have to acquit. But and the other one would be inordinate delay. But let me just point dito sa Martel, Your Honor. The new procurement law, yung ngayon po, kakalabas pa lang, does not have a penal provision. And it points back to Republic Act 3019, the Anti-Graft and Corrupt Practices Act. So even if final yung penal, sabihin natin, violation of the procurement law, we cannot convict if there is no manifest partiality, even bad faith, or gross inexcusable negligence. So I am thinking maybe kasi may violation pero walang penalty. Again, we go back to Article 5. I'm thinking of preparing a memorandum for our court to say na maybe we can bring this up to the Secretary of Justice, then of course to the Supreme Court first, then Secretary of Justice, then to the Executive Secretary for remedial legislation na baka dapat tignan din na dapat may penalty yung violation of the procurement law. Kasi kung we will be pointed back to 3019, paano na? That's one reason, Your Honor, bakit maraming dismissals. And then the other one, Your Honor, would be the matter of inordinate delay. Of course, this goes back to how long it took the Ombudsman to conduct preliminary investigation. So, but one thing here, Your Honor, kasi yung problema is, okay, iba-iba kasi yung periods na kinonsider ng Supreme Court in various cases as to what constitutes inordinate delay. May 1.5 years, may 3 years, so forth and so on. Sometimes 30 plus years, so talagang inordinate delay. Okay? But, okay. So ang problema lang is, there are cases na hindi pa nagpre-prescribe yung crime, pero meron ng inordinate delay. So, paano naman yun? The people have not been given the chance, di ba, to present their case in court, and then it is going to be dismissed because of inordinate delay. So, that's one thing sana na maybe dapat tignan.
So this will be my last question. I heard earlier you traced your route from
Cordillera, Your
Cordillera.
Honor. Yes,
So are you a member of IP?
yes, Your
Yes,
Honor. Oh, my great-grandmother was an
Yes.
Igorota.
Maybe your answer to this one would be biased. You remember the case of Cruz versus Secretary of Environment Natural Resources? It's about Sagani Cruz question the constitutionality of the IPRA law because it effectively gives the IPs the right to exploit, develop, and utilize natural resources found therein in those areas. And sabi naman ng petitioner, the Regalian doctrine should prevail because the state must have full control and supervision over our natural resources. Interestingly, that law was not declared not unconstitutional
Not unconstitutional.
because of the 7-7 vote. And we know that to declare it constitutional, 8-7. No?
Yes, sir.
Now, you are the 15th member of the Supreme Court, and assuming this case is still pending, would you take the side of the IPs saying that they have acquired it through acquisitive prescription and therefore the land has become private, ma'am, and therefore can be acquired by way of prescription by virtue of this native title? Or are you going to maintain that it is part of the state's ownership under the concept or doctrine of Regalian, under the concept of Regalian doctrine?
Again, Your Honor, maybe I will have to look again at the evidence, and see that, like, because there are some cases where ancestral land, ancestral land domain respected, this and that, di ba, in the Cordilleras. But in the city of Baguio, exempted because during the time of the Americans, when they came in, sabi ng Amerikano, ilista nyo na kung ano yung mga ancestral land nyo dito. Ilang beses pinagbigyan para maglista. And that's why, yun lang, hindi kasama yung sa city of
Because of
Baguio.
the general case law
Yes.
penned by Justice Leonen, right?
Yes, Your Honor.
Could be your stand. Ano ka ba for this case of Regalian doctrine or the native title?
Because of my native blood, Your Honor, di ba? No, but I said, I will look into it very well, Your Honor, depending on the case. Kasi this is not like a clear case na of a bad decision. Like,
Actually, in this case, it is not factual di ba? If you see,
yes.
di ba, parang sinabi lang, because of failure to reach the majority vote as required under the Constitution, the law is hereby declared not unconstitutional.
Yeah.
And justices had
Yes.
their separate opinions.
Yes, Your Honor. It would have been easier,
So
Your
it is
Honor.
not factual.
Yes, Your Honor. It would have been easier, Honor, if what we were talking of would be another case like Ruby versus Provincial Board of Mindoro, di ba, where Justice Malcolm said, yung mga mangyans na yan, di ba, basta, hindi, sinabi niyang kakaiba, sila doon sa mga ibang Pilipino. That's why they should go and stay in reservations like the American, the Native Americans of old. But now, even in the US, wala na yun. American Indians, American Native Americans can go wherever they please, whenever they please.
Thank you, Justice.
Thank you, sir.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Good afternoon.
Yeah.
Thank you very much, Attorney Mark. Good afternoon, Justice.
Yeah, good afternoon, sir.
Oh. Lunchtime. I represent the retired justices of the Supreme Court, so I will ask questions suggested by them.
Yes, sir.
I'll be skipping other questions because you may be hungry na.
Thank you, Your Honor.
Oh, from Justice Ascuna, what should the Supreme Court be doing differently and why?
Differently, Your Honor. Your Honor, maybe this is related to my earlier answer about why we do not get that big a budget. It's because the public, maybe, and some government agencies do not know the real work that we do for the country. So,
Justice, we heard you on that already.
yes, sir.
You fully explained it.
Yes, sir. Yes, sir.
We just go to certain topics not yet covered.
Not, yes, yes, Your Honor. Okay. So, aside from that, okay. Okay. I would say, Your Honor, that we should create more awareness because, Your Honor, we are the weakest branch of government. We don't have the power of the purse. We don't have an army. We don't have the police. We wait for cases to be brought to us before we can act. And that's why the people normally do not know what we do. For many of them, justice is an abstract concept. So I am thinking, Your Honor, that the Supreme Court maybe would do well in making sure that the work that we do is made known to the people through various ways, through social media or regular media, such that, and it should be done right away. So, for example, Your Honor, in my division at the Sandigan Bayan, we have agreed when it comes to our decisions, sometimes our decisions can run up to 150 pages or more, that we come up with a summary when we release, at the same time we release the decision, there is a summary so that this can be reported to the people as soon as possible. Kasi mamaya po, if it's reported many days after, it will not be news anymore. And then sometimes hindi magiging accurate yung pag-report. So we put already in the summary why this particular person is going to prison, why he is losing his freedom. Because we owe it not only to the public, but to the person who is who has been convicted and who is going to lose his freedom, Your Honor. That's one of the things, Your Honor, that I was thinking of.
We'll go to Justice Brion. Is there a difference between strict scrutiny and strict construction? Explain.
Strict construction, Your Honor, has more to do with statutory construction, and then strict scrutiny. I'm sorry, the definition escapes me on that part, Your Honor.
Yes, strict scrutiny. That's all. Yun lang ang sinulat niya.
Oo.
Strict scrutiny and strict construction.
Oo.
Although he has a suggested answer. Pero yun lang ang question niya.
Oo, yes, sir.
You can pass. It's all right.
Yes, Your Honor. Sorry for that.
Question number 2. Explain fully the concept of protected speech and unprotected speech.
Okay. Protected speech, Your Honor, freedom, right, as part of our right to freedom of expression. Unprotected speech would be those that will be harmful. So like libelous remarks.
Sige, I'll go to other questions. I'll go to the questions of Justice Tiham. Would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and other cyber crimes based on procedural grounds? Explain your answer.
I would rather, Your Honor, that the grounds would be substantive. Procedural grounds, maybe this would be maybe for other for crimes for cases not criminal. Maybe I will look into that. But when it comes to
Procedural grounds.
yes, Your Honor, no, I will not.
Okay. With what Supreme Court decisions of recent time do you disagree vehemently?
With what? Okay. Your Honor, one is that Ruby versus the provincial government of Mindoro. That's one regarding the Mangyans, and for the reasons which I have already stated. And I think the other one would be maybe I don't know if the title is Kagang, if that's the Kagang case where the Supreme Court.
Kagang versus Sandiganbayan?
No, that's not Kagang, sorry.
Oh.
No, the other case where regarding party list, Your Honor.
Oh, party list.
Yes, the first one, Your Honor, because okay, party list for the court recognized two. First one would be the marginalized sectors, allowing them to run as party list members, but it also allowed political parties with constituencies that are not so
Marginalized.
yes. No. So I feel, Your
So
Honor,
you disagree with
the second
subsequent
part, Your Honor,
decision.
because I feel it goes against the very purpose of why we should have party lists.
That is your view. That's all right, though.
Thank you, Your
I'll, you can answer this if you know. In the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th? If you know only,
The 10th justice.
yes.
Okay. The, it's the Solicitor General. Is this
You are correct.
the book by Archibald Cox, sir?
Yes.
Oh, because, yeah, okay, because he always argues before the Supreme Court.
What is the doctrine of rule of four adopted in the U.S. Supreme Court? Only if you know.
Rule of four.
Yes, doctrine of rule of four.
Okay, if I'm not mistaken, Your Honor, in the US, parties have to beg the Supreme Court to accept their cases. That's why
You studied in
not,
Harvard.
yeah,
Oh, you can easily answer.
not so many cases go to the Supreme Court. They have to beg the Supreme Court. So out of the 9, 4 must say, we will accept.
You're correct.
Ay, thank you, sir. Okay.
I have a few questions of my own. Konti lang. So
Thank you,
can
sir.
have your lunch na. What, excuse me, what are the essential elements of the freedom of expression?
Well, top of mind, I say, Your Honor, it must be responsible.
The two elements are freedom from previous restraint and second, freedom from subsequent punishment.
From subsequent.
Anyway,
Okay.
matagal na ninyong kinuha
Okay,
yung
sorry, Your
Constitution.
Honor.
Anyway, this is about elections, freedom of speech also. How about the ban on exit polls by the COMELEC? Is it constitutional?
The ban on
Exit polls by the COMELEC.
no, I would think not, Your Honor, because the people have already spoken. So the
So the ban is
is
Not?
is illegal. Oh,
it is allowed.
it should not be allowed, I would
should
think.
not be allowed.
Because the people have already spoken, and if they're thinking kasi baka trending or what, hindi, binibilang na yung boto eh.
So you can ban it for you.
I would,
Exit polls, the
Yes,
COMELEC
sir.
can ban it.
yes sir, habang bumuboto pa, di ba, sasabihin nila, the voting is ongoing and someone comes out and they interview, ganun ba?
Bawal na. Bawal, sabi ng COMELEC.
Sorry. Oh.
About you, what is
I
your
would
opinion?
I would think, sir, that it should be allowed.
It should be allowed.
It should be allowed.
The Supreme Court agrees with you.
Ay, thank you, sir.
Okay, again on freedom of speech and expression. This will be the last. What are the 3 tests by which by which the restraints on freedom of speech and expression are evaluated?
The 3 tests.
Yes.
Okay. The dangerous tendency test. The balancing of interest test. And the Brandenburg test. If
Clear and present danger test.
sorry. Okay.
Nasa na? Miranda bookstore. Yun.
Ay,
That will be all, Justice. Thank you very
sir,
much.
thank you so much.
Your excuse. Sir.
Thank you so much, sir.
Thank you, Justice Mendoza.
Thank Thank you po.
Thank you, Justice Miranda. Good luck po. Good afternoon, Your Honors. We will now continue with the public panel interview of the candidate for the position of Supreme Court Associate Justice. For this afternoon, Your Honor, the last candidate to be interviewed is Dean Maria Concepcion S. Noce. Good afternoon po, Dean Noce,
Good afternoon.
my former professor. The first to interview Dean Noce is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good afternoon, Dean.
Good
I
afternoon,
hope you
Your
had a
Honor.
good lunch.
Justice Puy, yes.
Is this your first time to apply for the position of Associate Justice of the Supreme Court?
Yes, Your Honor. This is my very first time, and my very first time to apply for a position in the judiciary, Your Honor.
May I know what inspired you to apply at this point in time wherein you are now 67 years old?
Yes, Your Honor, that's
And-
correct.
And if appointed, you will serve for maybe less than 3 years.
Yes, Your Honor.
Instead of applying earlier so you can spend more years in the Supreme Court.
Yes, Your Honor. Well, there is a time for everything, I suppose, Your Honor. And now, I believe, is the right and the right time for me to apply for this position. Well, in this world, in today's world, Your Honor, where youth and newness are often celebrated, sometimes or oftentimes an invaluable asset such as age is often overlooked. And I hope this doesn't happen in my case. If I may just give a brief narrative of my professional background, Your Honor.
Yes, please. That's my
Yes.
next question.
Oh,
So
okay.
proceed.
Yes. Yes, if Your Honor, please, I joined the government service immediately after I passed the bar, or even before I passed the bar. I already worked in the office of the President, of the Philippines, as Presidential Staff Legal Officer, and at that time I was writing decisions and drafting executive issuances, for the office of the President.
Which president?
President Marcos, Ferdinand Marcos Sr.
Please proceed.
Yes, Your Honor. And the opportunity came for me to work in a law office, which was then headed by then Associate Justice of the Supreme Court, Jose Y. Feria. And of course, he is a man I looked up to and admired because of the person that he was, and because of his works. He was a remedial law expert. He was God-fearing. He was upright. He was humble. He was competent. He was knowledgeable in so many things. And I thought that to start my career under his guidance and tutelage was just perfect. And that would also give me the opportunity to hone my litigation skills, which I have always wanted to go into as an area of law practice. And so I joined this firm. I was with that firm for 17 years. I worked very closely with Justice Jose Y. Feria. And, at that time, I already started teaching in different law schools. And after that, I also had the opportunity to go into advocacy. And this was advocacy for family and life. And of course, after that, all this time I was already in the academe. And then when, also the opportunity came for me to be involved in setting up the law school. And this is the University of Asia and the Pacific Institute of Law. And I was part of the committee that, was tasked with establishing the law school. And after that, I became the founding dean of the Institute of Law. And, we started from ground zero. I had to, of course, with the help of several people, I had to put up everything, policies, the curriculum. I had to fill up the roster of reputable faculty, and and then of course, it wasn't. We had to make sure that I had enough number of students who were enrolled, and it was on. We had to secure a license to operate on a yearly basis until we were able to get a license to operate the 4-year JD program. And at this point, if I may also state that from the first batch of graduates until 2022, we had an exemplary performance in the bar exams. And
Is it 100%?
from 2019, from 2019 to 2022, yes, Your Honor, we had 100% passing rate.
How many students?
At the start, I think less than 10, and then when I left, about 17 or 18. And all 46 who graduated from the Institute of Law when I left, they all took the bar, passed the bar, and are now well placed in different areas of law practice. And so, when the vacancy in 2022 in the Supreme Court came, I was still in UANP, trying to lay down, putting the finishing touches, so to speak, of the law school. And it wasn't the right time for me to leave. And so when I had laid down the groundwork, everything, we had all the policies in place, the curriculum in place, the roster of faculty was complete, and with the achievements of 100% passing rate for 4 consecutive years, I said, it's time for me to move on. When I left government service, I promised myself I would go back to government service when I feel equipped to make a significant contribution to the justice system. And so when I left UANP, I became very busy with the Philippine Judicial Academy. I was an active, I have been, and I am still now an active professorial lecturer. And I participate in different programs, and I give lectures to judges, Your Honor. And so I said, when the opportunity came for me to apply because of the vacancy or the vacancy that would be created with the retirement of the Honorable Justice Mario Lopez, I said, this is the right time and the right time for me to apply. At this point, you said, at this point in my career, yes, Your Honor. At this point in my career, there is only one desire. There's only one heart's desire, if I may even call it that, Your Honor, and that is to make a meaningful and significant contribution to the judicial system. And I believe that the Supreme Court is a most fitting avenue to cap my career's journey. And law has been my calling and my passion for nearly all my life. And at this point, I hope I am given the opportunity to take this path and to make a significant contribution, because I believe that I am prepared to do that, Your Honor, at this point in my career.
Do you still maintain the MCS Noche Law Office?
Yes, Your Honor. But that is now a small law firm, Your Honor. With,
You have associates?
just one, Your
I
Honor, because when I went and became the dean of UANP, I had a very limited law practice because most of my time was concentrated on establishing the law school, Your Honor.
You were also connected with the Winstead McGuire Seacrest Nick law firm?
That was when I studied in the U.S., Your Honor. That was part of the internship that I had the privilege of, working with this law firm, Your Honor. That was many years
What
ago.
was your course in the US?
International and Comparative Law, Your Honor.
In what school?
In Southern Methodist University, Dedman School of Law.
Yeah, right.
In Dallas, Texas, Your Honor, for my Master of Laws degree, Your Honor.
In your PDS, it appears that you have 41 years of experience in civil litigation, 10 years in criminal practice, and 5 cases handled in the appellate courts. Can you share what nature of cases you have handled in the past?
Yes, Your Honor. Well, I am now, of course, a private practitioner and a consultant in a holding company with interests in energy. And in the past, of course, as I mentioned earlier, I have been heavily involved in advocacy for family and life. And because of that, I had the opportunity to appear before the Supreme Court en banc. And that was when, the RH law was then was being questioned. And I represented the petitioners in that case. And of course, I also had, mostly civil cases. I also went into corporate work, also did corporate work, Your Honor, and but hardly did any criminal law practice, Your Honor.
Because in your PDS, it states 10 years in criminal practice.
Well, at the start of my career,
you were-
yes, Your Honor, I was doing, everything. Civil, corporate, criminal cases.
How about labor?
I did some labor cases, but
Also.
not too many labor cases, Your Honor.
Can you share about your advocacy? Because you have a nomination from the Cardinal Ambo.
Yes, Your Honor.
Yes.
There was a point in my personal life and in my professional life, Your Honor, that I wanted to do something really meaningful. I devoted long hours in work, staying very late in the office, and probably, I got burnt out. And so I was looking for something meaningful to do. And so I was invited to join this organization, Alliance for the Family Foundation Philippines, Inc., which is a secular organization that is involved in promoting and protecting, family and life, no? And anything that involves the family or impacts on the family and life, then it gets involved. And so there were several bills in Congress that were pending then. In fact, Alfie was born because of the divorce bill then pending in Congress. And when I joined, the controversy on the RH bill was raging. And so we felt that it was something that would impact on not only family, but more particularly life or the right to life. And so my organization and I, as as a lawyer, became heavily involved in this advocacy. And Your Honor, it was something that gave meaning to the law practice that I've had, and there are no billable hours and long hours. We need to work, or we needed to work at that time during the RH bill controversy. But knowing that you're doing something that advances the interest of family and life, I think it's worth more than any amount or any compensation or any fee that a client can give you, can pay.
How long ago have you been engaged? For how many years have you been involved in this advocacy?
I have been the president of Alliance for the Family Foundation Philippines, Inc. for 14 years now. So I must have been involved in this for like 15, 16, more than at least 15 years, Your Honor.
If appointed as Associate Justice of the Supreme Court, what innovations would you recommend to further enhance the speedy delivery of justice in our courts?
If Your Honor, please, I think that we need good judges. I think who will facilitate the disposition of cases, and I think the innovations that have been introduced in civil procedure, like the judicial affidavit, the use of judicial affidavits at the very start, this have facilitated the speedy disposition of cases. Yes, and I think the judges should really be incentivized to
In
dispose.
what way?
Yes, by means of rewarding them, acknowledging them, probably giving them a promotion if they, if they are able to dispose of the cases as speedily as possible, as speedily as they are, supposed to. So I think the merit system will work if this is applied to members of the judiciary, Your Honor.
Have you handled cases for declaration of nullity of marriage?
No, Your Honor. I purposely shied away from from handling any case regarding annulment.
Not at all.
Not at all, Your Honor.
How
Kasi-
about other family court cases involving minor victims, VAUSI cases?
Yes. Well, regarding custody of minor children, Your Honor, I had the opportunity to do that, Your Honor.
Not even separation of property?
Separation of
You
property.
accept that?
Yes,
I
yes,
see.
of course, yes, Honor. But not annulment of marriages.
Would
Your
you be familiar with the unavailable child doctrine?
Honor.
In child abuse cases?
In child abuse cases,
Yes.
I am afraid I'm not familiar with that, Your Honor.
The testimony of the child is dispensed with because of their vulnerability.
Oh, okay.
Yes.
Yes, Your
So now it is allowed for the case to
To
go
prosper.
through. Yes.
To prosper. Yes, Your Honor.
Even
Yes,
if
Your
the
Honor.
child is unavailable.
Okay.
What about the limitations on Congress in the exercise of the power of legislative investigation?
What is that again, Your Honor? What about-
Limitations when the Congress exercises legislative investigation? What are the limitations or requirements that must be observed?
Yes, Your Honor. Well, of course, the Congress will have to respect the fundamental rights of people who have been invited to appear before it for, to shed light on certain matters, Your Honor. And of course, the provision also requires that the rules of procedure have been published and have been clear to everyone. And there's one more.
Purpose.
Okay.
Purpose of the investigation.
The purpose will have to be clear, Your Honor, and will have to be, will have to be
In aid of
specified. In aid
legislation.
of legislation, yes, Your Honor.
Do you agree with the ongoing or the many investigations in aid of legislations? Do you have any comment? Do you think it is helpful? It is
Yes,
advantageous?
yes.
What's your stand?
Unfortunately, from what I have seen so far, they are not necessarily in aid of legislation, Your Honor. And in not all instances are the rights of the people who have been invited to appear before it have been respected. No? So I cannot also believe that sometimes the proceedings have been quite messy and have not really, followed the rules of procedure. Yes, Your Honor, but I think, they have been used to it, and people also have been used to that kind of, legislative inquiry, so that probably no questions are really raised up to the appropriate courts for review.
That's my last question. Good luck to you, Dean Noche.
Thank you very much, Your Honor.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Marife. Good afternoon, Dean.
Yes, good afternoon, sir.
Foremost, I would like to apologize for misspelling your name. You see that on the table sign.
Oh, yes, yes. Oh, well, it's...
I was about to ask you, why is your name different? Then I have to look at your profile. It was us who committed the
Concepcion.
mistake.
Yes,
Yeah,
yes.
okay. I have two sets of questions, Dean. One comes from the Secretary of Justice, and the other set would be my own set of questions coming from the members of the Academy. So I'll read the question of the Secretary first. So, number one, as a former Dean of UANP School of Law, you oversaw a law school that consistently achieved a 100% bar passing rate under your leadership. Do you believe that the current bar examination system is an effective measure of a law graduate's competence? And if not, what reforms would you advocate for?
If Your Honor, please, I think the bar examination is one measure is one way of measuring the competence of law students. No? But I think that's not the only measure of competence. I think I was a bar examiner in the past 2024 bar exams, Your Honor. And a common feedback among examiners, which I share heavily, Your Honor, is the lack of the lack of ability of most of the bar examinees to express themselves or their opinions, their answers in the case of the bar exams, their arguments, in writing. They have difficulty to express. There are problems in grammar, and sometimes it's very difficult to understand, what they really want to convey. I think we have to focus on the basics, Your Honor, because I think we have to remember that lawyering is advocating. It is an advocacy both in writing and orally. So the students, the law students will have to be trained how to be proficient in both oral and written advocacy. And probably that has to start really from not even, probably law school is already quite late, but that may have to start earlier. And that probably, also is a manifestation of something that's amiss in our educational system, Your Honor.
Second question. As an accredited mediator with the Singapore International Mediation Institute, you are trained in alternative dispute resolution. So question is, do you believe the Supreme Court should take a more active role in promoting mediation as a primary means of resolving disputes? If yes, how would you propose to institutionalize this approach?
Yes, Your Honor, I believe mediation should be an effective means of dispute resolution. In mediation, of course, a third party does not really impose solutions and does not, take sides, no? But just tries to facilitate communication and negotiation. So I think it's very important, and I think there are now moves, no, as part of the innovation program, no, in the Supreme Court to move towards mediation, and I would really try to encourage something like that, because it's we have to. That's one way of the court dockets being declogged. No? If we're able to get the parties to communicate, because a lot of cases, even those that have gone up to the Supreme Court, can still be resolved, no, by making sure that the communication lines are open. No? So and a lot of things can still be subject to negotiation and eventually to settlement.
Third question. Your PDS reveals that you were a candidate for mayor of Taal,
Yes.
Batangas,
Yes.
in the 2004 general election, but unfortunately lost.
Yes.
How did this experience in politics shape your understanding of law, governance, and the role of the judiciary?
All right. At that time, Your Honor, that was 2004.
If I may interrupt, no, who won during that election?
Mayor Diosdado Cabrera, who is not active anymore. Yes.
Not a certain Mercado. not that one.
Actually, we before I ran for mayor, we both ran as councilors. No, we call them as councilors, and we both won. He was number one. I was number two, and of course, Mayor Mercado was more fortunate, I guess, than I was, because he tried to run for mayor and he made it.
Sorry, no, but for interrupting, I was just curious. The question would be, how did this experience in politics shape your understanding of law, governance, and the role of the judiciary?
Role of the judiciary and governance. Well, governance. It was, if I may, be very honest about it. It wasn't a very good experience for me. I was probably very idealistic and probably naive in a sense. No, I thought that, if you have a platform of government, if you have, a sincere desire to serve your people, and you are able to communicate, this desire and this and the platform that you have to the people against a government then that was not exactly desirable in so many ways. I thought that that would be sufficient. I thought that I could get people to wake up and vote for honesty, for integrity, for moral uprightness. But I was wrong, completely wrong. Yeah, there were many allegations of irregularities. And I did not think at that time to, waste my time further and bring these matters to court. I just felt that, I gave myself, no? I was ready to give myself, and I made that known to the people. But, it wasn't enough. My good intentions were not enough. So I just moved on and, concentrated on my law career again. And fortunately, I got into so many meaningful projects after that. And so I'm now just a conscientious voter, and I no more politics in the sense that I don't have political ambitions anymore.
I just imagine if you won, you could not have been here right now. That's how
Yes,
God works
yes,
for
yes,
us.
Yes, Your Honor. Yeah, God has other plans for me, Your
Yes.
Honor.
Number 4, it can be said that our Constitution shares some similarities with the U.S. Constitution. So as a hopeful final arbiter of constitutional issues, being a magistrate of the Supreme Court, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by the U.S. Jurisprudence despite similarities in our constitutions?
Yes, Your Honor. I, reading the cases, the American cases, I think that the philosophy observed by most justices of the Supreme Court in the U.S. is judicial activism. I am for judicial restraint, Your Honor, and I go for the textual approach and the originalist approach. I believe, Your Honor, that the textual approach should be used in interpreting the Constitution and the statutes. So, which means we refer to the plain meaning of the text, and the way it was understood, by the common people at the time that the Constitution was adopted or the statute was enacted. And if that is not clear, or the text is ambiguous, then the next approach I would take would be to go to the determine the original intention of the framers of the Constitution, or the intention of the legislators, by reviewing the records of the proceedings of the Constitutional Commission and the records of the debates. And so judicial restraint, I will practice judicial restraint by doing that, Your Honor, okay? By resorting to textual approach and then to originalist approach. Judicial activism is, to me, quite, it disturbs me, Your Honor, because I think there's a real risk of the justices, substituting their personal opinion for what the Constitution really says, no? And that should not be the case. And there's also a real risk of the judiciary legislating, no? Because they would want to address certain developments in society that they think the legislator is not able to address. And so, in effect, they're usurping the legislative function. So I will go against judicial activism, Your Honor.
Well, maybe that answer would also be applicable to the number 5 question, but you can still expound, and I will nonetheless ask the 5th question. With your long years of practice of law, and now as an applicant for a Supreme Court justice position, can you share to us your judicial philosophy?
Okay. I have mentioned part of it, but okay. My judicial philosophy is anchored on my steadfast commitment to the principles and provisions, no, stated in the 1987 Constitution, and my adherence to the rule of law. All right. And as I mentioned earlier, the way I would interpret the Constitution and the statutes would be through the textual approach and the originalist approach. No? So I will not go into that again. I believe that law is a potent vehicle or tool, no, to foster the common good, no, to safeguard individual rights, and to respect the inherent dignity of every human person. Okay? And but always under the rule of law. All right. So when we talk of common good, we refer to the holistic welfare of individuals, and this encompass various assets of a person's life, no, and this refers to social, cultural, political, ethical, and even environmental dimensions. No? So it's very important to have a comprehensive approach, no, to achieving the common good. No? And if I may say this, Your Honor, inspired by the insights of Pope Francis, the late Pope Francis, no, in his encyclical Laudato Si. Okay, I have incorporated, no, his concept or principle of integral ecology in my philosophy. This concept of integral ecology, this underscores the essential link and mutual dependency of human society or human communities with the environment. No? And so it's very important that when you think of fostering, no, and promoting the common good, okay, you also think of the common good of the human society as interlinked with the well-being of the surrounding environment. No? Because these elements are fundamentally intertwined. That's what I believe, Your Honor. So I think that with this integrated and comprehensive approach, we can be assured that the efforts, no, to achieving the common good, no, will always take into consideration the interconnectedness, no, of human societies with the physical world. And I believe this is an approach that will secure a sustaining or sustainable legacy for the benefit of the present and the future generations. We must remember that the Constitution talks also of conserving and developing patrimony, no, and also of posterity, no, of future generations. So my judicial philosophy takes that into consideration, Your Honor.
Okay. I think I know the answer to this question. Do you have a particular justice here or elsewhere whom you consider an idol? And why?
I think I mentioned his name earlier. He was, I really look up to him. And he was my mentor, and I owe him a lot. Pardon? Okay, yeah, that's okay.
Ready for the next one, Dean? So the next one would be, assuming you were appointed to the Supreme Court and given the short number of years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
Yes, I realize, I may not have, more, sufficient time as the others do, but I can contribute in the realm of education and making, providing legal assistance to the underprivileged in those areas. And I will be ready to contribute to, any program that I may be assigned to. But as I said, especially because of my experience in the academe, that probably on matters relating to education and, providing legal assistance, significant legal assistance to the underprivileged, I think.
The next question, in the context of criminal law, how do you reconcile the principle of nullum crimen sine lege, or no crime without law, with the evolving nature of crimes in the digital age, such as cybercrimes and artificial intelligence-assisted offenses? So, should the judiciary have the power to recognize new crimes absent any explicit legislative provision?
Well, the role of the judiciary is not really legislating. No? The role of the judiciary is interpreting laws. Okay, so there will have to be laws. So it's a matter of considering realities, no, and advancements in technology. Then probably it's in the interpretation of laws that the judiciary will have a significant contribution. So I don't know if that is sufficient.
Next one, the principle of proportionality requires that the punishment must fit the crime. So how do you view the constitutionality of the mandatory minimum sentences which limit judicial discretion? Should the judiciary have the power to invalidate such laws if they lead to unjust results?
Well, of course, the justice to be meaningful should really be fair, and so the judiciary will have a big role in making sure that the justice dispensed is really meaningful and really fair. So again, I think it is incumbent upon the judiciary to probably exercise an interpretation that will bring about that kind of a justice, regardless of what the law actually provides. So it's in the interpretation, I think, that something that's impressed with empathy, more compassion, probably. But that is upon the judiciary. With the judiciary interpreting the law could bring that about, Your Honor, I believe.
Last question. In your view, does the doctrine of presumption of innocence extend beyond the trial stage to public perception and media coverage? How should the judiciary protect the presumption of innocence in an era of widespread media sensationalism?
Okay, I think, the judiciary should do everything to ensure that it remains impartial, that it remains independent, that it renders decisions only based on facts and the law. So the judiciary should insulate itself from anything, no? Including probably social media, if so that it will be able to do its job effectively and comply with what is required by the law.
So this will be my set of questions, Dean. So if appointed, what would the stakeholders expect from you?
Well, Your Honor, I have always been, a hard worker. I've always believed in hard work and focus. In fact, I always tell this to my students: hard work always pays off. Probably not immediately, but it will eventually pay off. So, and I am, if I may say this, I am a woman of great faith. And I believe that everything that I have, no, and everything that I am, I owe it to my Lord and Creator. And so, as I said, my only heart's desire at this point is to give a meaningful contribution to the interest of justice or to the justice system. And so I think they can expect, nothing less than, a work that I cannot, a work that I can only, a work that I will want to be able to present to my Creator, when the time comes. So that's the only thing I want at this point, a life of service and a life of meaning and purpose, Your Honor.
So admittedly, Dean, you haven't worked in the judiciary. I mean, not been a judge or a justice, no?
Yes,
So
Your Honor.
what would be your advantage over other applicants? And what is your understanding of judicial careerism?
If Your Honor, please, yes, I have been in, various stages of the judicial process. I have had hands-on experience, no, from initiation of, of complaints, from initiatory pleadings, from gathering of evidence, preparation of witnesses, examination of witnesses, preparation of all kinds of pleadings, and I think for decision making, I think all of these stages, no, are very, very important, and I think the practical experience that I've had in all of these areas would more than compensate for the gaps, if you may call it that, in my judicial experience, and judicial careerism, of course. I take note of that, but I think that the objective to develop and respect careerism in the judiciary is very valid objective and goal. But I think people from the private sector, no? People who have had extensive experience in diverse areas of law, no? Should not also be left out, no? And should not be ignored. People who are otherwise qualified, were it not for their lack of experience in the judiciary, to dispense justice, no? In the highest court of the land. No? I think private practitioners like myself, who I believe have the qualifications and the skill set to be able to contribute significantly to the judicial system, should also be considered.
So earlier, Dean, I heard that you purposefully hesitated in handling declaration of nullity cases, annulment of cases. Diba? The question now is, it's very, in the Supreme Court in some instances now would invoke that doctrine insofar as political questions are concerned. Now, if you are going, no, if you are appointed as an associate justice of the Supreme Court, how are you going to view cases of this nature, of cases involving the declaration of nullity of marriage for annulment?
If Your Honor, please, may I just explain why I, purposely shied away from those cases. I believe that, it is, I, as a lawyer, cannot and will not be able to know exactly what goes on, if I may say this, in the bedroom. So, that's how important to me family and marriage is. No? So I realize that there may be grounds for nullity of well, of course, especially for declaration of nullity of marriages, no, because there's no marriage to speak of at the very start. But even that, I said I will not want to have a hand, no, as a practitioner, Your Honor, to spell the death, no, of a marriage, no, and to, in that sense, destroy the family. But if Your Honor, please, as a magistrate, it is my judicial philosophy that the Constitution and the statute will be my North Star. Okay, so I will have to be to do that, no, follow what the Constitution says, follow what the statute says, and of course I will have to rule or make a decision based on the facts and the legal arguments presented. So that's a different case, Your Honor, being a magistrate and being a
Your personal
lawyer,
bias
an
would not
advocate.
in any way, your personal bias as a practitioner would not in any way
No, Your Honor.
set
Yes,
in when you
yes,
become,
yes,
okay.
yes.
I heard earlier and I read that you are into a practice of energy law.
Yes, Your Honor.
So, very old law, the Petroleum Act.
Or, yeah.
Very old, 1949. Were you born at that time?
No, no,
Not.
no. No.
So
not
under
yet,
this
Your Honor.
Petroleum Act of very old law, 1949, we have 5 concessions. Do you remember them? What are those 5 concessions?
No, Your Honor, I've only energy insofar as electricity is concerned, Your Honor. I've not dealt with petroleum, Your Honor. So I'm very sorry
So,
about that, Your Honor.
this is actually a case, no? But there are 5 concessions. Number 1 is the non-exclusive exploitation permit, the exploitation permit, the exploitation concession, exploration concession, the refinery concession, and the pipeline concession. So my question pertains to pipeline, and there is a Supreme Court case about that one. No? So can we consider a pipeline no, a common carriage.
A common.
Carriage. This is how the case goes, no? So in Batangas, you're from Batangas, na? The local government assess the pipeline concessionaire with a local tax. So the pipeline concessionaire, no, protested, no, on the imposition of tax, local tax, saying that they have been franchised by the national government because they are a common carriage and therefore exempted from local taxation. So the question there in the Supreme Court case is, can we consider this pipeline, no, a common carriage for the purpose of taxation? I thought you would be able to know kasi you're into energy.
But I only deal with energy related to electricity, Your Honor. I apologize.
So this is about a recent case. No? We have the Republic Act number 8479, the Downstream Oil Industry Deregulation Act, no, of 1998, which authorizes the Department of Energy to take over operations of private entities in oil industry under given circumstances. So, and if you try to look at our Constitution, it is permitted naman, di ba? So the Constitution says the state can take over or have a direct operation of these privately owned public utilities affected with public interest. So it is permitted under the Constitution. The question now is, can the executive agency, other than the president, properly exercise that such takeover power? It's a recent decision from the court.
The Department of Energy, are you referring, Your Honor,
Diba?
to Department of
Ordinarily,
Energy?
it is the president that would have or take the power to take over the operation of these public utilities. But now, can the secretary, no, cabinet secretary, no, the secretary of energy, for this matter, exercise such power of takeover?
Okay, I think properties involved there, and no person shall be deprived of life, liberty, or property without due process of law. So
Actually, it is in times of
yeah,
the Yolanda, di ba? The president at that time, no, binigay niya the power to the secretary. So there were questions. It is not proper because under the Constitution, it is only the president. The secretary cannot do that.
yes, yes. On something as significant as that, no, and a takeover.
And there's a national emergency at that time because of the Yolanda, the typhoon. So, would it be permitted? No, actually, the Supreme Court here applied the case of or the principle of qualified political agency, saying that the secretary,
president can delegate.
yeah, the secretary can do that under the alter ego doctrine. But of course, petitioner says no. It must be strictly done by the president.
There has to be a strict, I think, interpretation of the law because, I think we cannot just delegate to an agency that kind of a power, no, which is just given to the president. So I think, and something that involves, deprivation of private property, Your Honor. So I think there will have to be, you have to consider first if there's really, an emergency, and if it will really serve the public interest, Your Honor.
You joined the dissent of Justice Kagiwa. That was also his decision.
Oh, I see.
Sabi niya na,
Okay.
or opinion,
Yeah.
that it cannot be properly delegated to the secretary. But
Yes.
Justice Leon, if I'm not mistaken, said there could be a valid delegation under the alter ego doctrine. So
I see.
interesting.
Yes.
one
so
in
interesting.
the practice of energy law.
Right,
No.
right.
Uh, well, other question. You're the dean of UANP, former dean.
Former dean, yes.
So
Your Honor.
are you aware of the four essentials of academic freedom?
Well, what constitutes academic freedom?
Yes.
Yes. Yes. I mean, what to teach, how to teach, who to accept. What else? For. Yeah.
That's okay,
So-
Dino. Actually, this is one case also decided by the court. No, this about UPLB. No, they were uh, asked to implement the study of BT talong, the genetically modified talong. Because prior to that, I don't know if you're aware of this case, the farmers have been pestered by pest in their eggplant.
Yes.
So, of course, to help the plight of these farmers, sabi nila, it's good to modify this talong so that there will be no pest and therefore increase the productivity of our local farmers.
Yes.
The Greenpeace movement filed a case for the issuance of writ of kalikasan under the principle of the precautionary principle.
Precautionary principle.
Now, one of the respondents in that case is UPLB, saying that if we will stop the implementation of this program, it will violate our academic freedom. So what would be your position on that?
Academic
Because
freedom.
the other side tells, of course, the writ of kalikasan says it violates the right to healthful and balanced ecology.
Yes,
No?
yes,
Kasi
yes.
this genetically modified talong could probably cause some health problems to the consumers. No? But at the same time, you know that it would violate the academic freedom of UP. So what is your take on that? Which right would you sustain?
Okay, so it's academic freedom and against the right to healthful and balanced ecology. No? So what is the compelling interest here? The compelling interest is the right to healthful and balanced ecology, which is I would say that's that's a fundamental. You can say that that's a fundamental right. So what kind of measure are you going to use? Okay, in this case, no. So there has to be a compelling, state interest here. And then, is it the least restrictive means available, which is to stop the UPLB, and then will stopping it serve the compelling government interest? I think this matters will have to be balanced, no, and will have to be
So if there is
determined.
equipoise,
Pardon?
if there is equipoise, so which right would you sustain?
Okay.
It's so difficult to resolve two conflicting rights, di ba? Constitutional rights.
Yes, if
So-
there's really no other means, no, to serve the interest of healthful and balanced ecology, which is very important. If that is the only way, stopping, that project of UPLB, then I think I would go for, and there's clear evidence that this is going to be affected, no, the healthful and balanced ecology. Then I would go for the healthful and balanced ecology, Your Honor.
So earlier, no, I heard you, Dean, being, if given a situation, you will be more restrained in interpreting constitutional provisions.
Yes, yes.
Now, you are confronted, and you are aware, Dean, probably aware that there are several economic provisions under our Constitution. So now, which approach are you going to use? No, are you be more restrictive in interpreting these economic provisions? No, that such that no, you would give life to this provision in the Constitution, wherein it says that the Declaration of Policies that natural resources should be effectively controlled by Filipinos, or would you or probably lean towards economic growth, no? Such that you would allow investors, so long as it is not it does not transgress our constitution.
I always believe in looking at different dimensions of things. No? So, as I said earlier, in my judicial philosophy, I'd like a comprehensive and integrated approach. So, I think economic growth per se is good. But I think we have to consider other dimensions. No? Will that serve, and will that comply with other provisions of the Constitution? But so several other things that need to be considered. Will that promote public good, public interest, public welfare? Because I think economic growth, should not be, taken in isolation from the other dimensions of life. So I think that's how I will take it.
Yeah, last question, Dean. I'm sure you're aware of the Rule of Law Index. Yeah, are you familiar with the Rule of Law Index? So every now and then, the Philippines has been assessed, no, by internationally as to our Rule of Law Index, the standing, no, the percentage, the rate. Because this is one of the barometers for global competitiveness. So investors would go here in the Philippines if they believe we have a working judiciary. So global competitiveness is one of the barometers, no, of this Rule of Law Index. Now, adherence to the principles of good governance is one key, no, to address this one. So what would be your concrete plans, no? You want to implement in the Supreme Court, should you be appointed, no? That would increase the Philippines' standing in this Rule of Law Index, particularly focusing on the principle of public participation.
Okay, I think the Supreme Court will have to be more accessible to the people. Okay, the people should have that confidence and trust in the Supreme Court so much that they will feel that there is that court, the highest court, that will look after my welfare, that will make sure that I get the justice that I deserve. A Supreme Court that is clean, that's transparent, that's upright, that's judicious in the manner it renders its decisions. And it also goes with also the people, the members of, that comprise the Supreme Court. No?
So how are you going to do that? What would be your concrete plans?
Yes, I think now the Supreme Court is moving in that direction. There are efforts towards that, but because I think the Supreme Court through the communications office or is into social media, no? Without really really trying to engage in other facets of social media that are unbecoming of the highest court of the land. So I would encourage that to bring the court to closer to the people by making reports, no, to the people on what's happening in the Supreme Court, the decisions, no, the members of the Supreme Court, and what's happening, and all of that. No, I think that's one way of doing it. And of course, also be how is this? Also for the Supreme Court to be mindful of its role, as the vanguard of the Constitution, and the dispenser of justice. So I think that the Supreme Court will and the members will just have to be very mindful of that role.
Thank you, Tin. That will be my last
Yeah,
question.
thank you too.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Manny. Good afternoon, Dean.
Good afternoon, Your Honor.
I represent the retired justices of the Supreme Court, so they course their questions through me. So I will ask them. I'll begin with someone you know, Justice Brion.
Oh,
But he submitted only 3 questions. So I asked him, can you give me one more? And he texted me, ask the history of Taal, why and how it was connected to Pasig River. I just read it. I will not ask you because we have no time. First question is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why, and explain fully.
has a more profound influence on the law.
On law,
On law.
yes.
Okay, of course, the Chief Justice as the head of the Supreme Court, and of course is the head of the Supreme Court, which is tasked to interpret the law. And of course, the President is supposed to implement the law. Okay, so it's between implementation and interpretation. Okay. But then again, the implementation could be subject of judicial review. So, of course, now judicial review has been expanded. Okay, so it's not just about actual controversies. The court's not just about resolving actual controversies involving demandable and enforceable rights, but it also goes to the extent of determining whether an instrumentality or branch of government has been guilty of grave abuse of discretion. And so I would think that in the end, it is a Supreme Court who has the final say what the law is, that will have the most profound influence on law. And of course, as the Chief Justice representing the Supreme Court, will have that kind of an impact on law.
Question number 2. Is there a difference between strict scrutiny and strict construction of statutes? That is his question.
Okay, strict scrutiny. That's a strict scrutiny test.
Yes, in strict construction
yeah.
of statutes.
That test is usually used to determine. I think that is used in equal protection controversies, no? And that is to determine whether a state act of interference, no, is constitutional or not. And so to use that test, there has to be, with that test, you have to determine the compelling state interest involved, and also whether the means employed is the least restrictive means available. And so I think, the government or the state has the burden of proof to show that the strict scrutiny test has been passed by because there's a compelling state interest involved in the interference or in the act of government, and that is the least restrictive means or method that could be employed. So if this methods are observed and are complied with, then I would think that the state would be justified, no, in making the interference, no, or would be justified, no, or the act of the state would be rendered valid and constitutional.
Just make it brief. What is really the essential difference between strict construction and strict scrutiny?
Okay, strict construction, Your Honor,
Briefly only.
is, I think, very much like the textual approach that I talked about earlier. I think it is, interpreting, a statute,
Yes,
no,
it's a
by
rule in
means
legal
of,
hermeneutics.
looking at the plain meaning of the text. That I think is the strict construction.
Yes. And strict scrutiny is a standard of
Yeah, it's a
judicial
test.
review,
It's a test.
which you explained earlier.
Yeah.
Justice Prion cited the case of Estrada versus Sandigan Bayan.
Yes.
Explain fully the concept of protected speech and unprotected speech.
Okay. Well, protected speech is it's protected by the Constitution, no, as part of the freedom of expression. And again, it's a fundamental right. And of course, I think strict scrutiny or a compelling state interest test will have to be employed for the protected, in order to, for protected speech. However, unprotected speech is, refers to, hate language or anything that, incites someone to commit a crime. So that would, and that's not protected under the Constitution, obviously, Your Honor.
We will cover that later, later. From Justice Abad, one of those whom you cited as a reference.
Yes.
What rule governs the interpretation of laws when applied to actual cases?
What rule or what approach is that? So I would,
When applied to actual cases.
when applied to actual cases, how do you interpret the laws? Is that the question, Your Honor? Plain, you just, I think the plain meaning of the text of the law, I think that's how to interpret that law,
That
and
is
that's how
correct.
you apply it to the case before you.
Yes, that is correct. Unless this will result in patent injustice, you apply the literal meaning. That is the suggested answer of Din Abad.
All right, thank you.
Okay. What area of the law do you feel you can immensely contribute to in its development? What area of the law?
What area of the law?
Justice Abad also.
Yes, probably in procedural law, Your Honor.
Yes.
I think because I have endeavored to write several books on
Remedial law.
on a remedial law, Your Honor. In fact, I just came out with a book first week of May, Your Honor. With a new
Thank you.
book.
From Justice Ascuna, what should the Supreme Court be doing differently and why?
Be doing differently. Okay, so that's a difficult question, Your Honor. Well, I was just reading some decisions of the Supreme Court, and I wish the Supreme Court had ruled differently. So, if that's one way, because I believe, yes.
What should the Supreme Court be doing differently? Not deciding differently, doing differently. Maybe it's policy.
In its policy,
Maybe, yes, direction, probably.
I think that's one thing I wish for the Supreme Court to be more consistent. You know, in the decisions that
Presently,
have
it's
been
not-
promulgated.
Presently, it's not consistent. The decisions are not consistent.
Some decisions I've read, Your Honor. Yes. Well, I would dissent. Let's put it this way, Your Honor. I would dissent. I would have a dissenting opinion on some of the decisions that have been rendered, Your Honor, and
Okay,
promulgated.
that is covered by one question of Justice Tiham. What Supreme Court decisions of recent time do you disagree with vehemently? So now you can answer.
Okay. Well, if I may mention Republic versus Manalo,
Oh,
it's on foreign divorce. Because Article 26 is very clear. I believe that if it refers to a foreign divorce obtained by the foreign spouse, no. And of course, in relation to that's Article 26, paragraph 2. So foreign divorce, of course, is allowed, provided that it is. I mean, as I read Article 26, paragraph 2, as I read it, foreign divorce is, going to be recognized or may be recognized by our local courts, provided it's a foreign divorce that's obtained by the foreign spouse, and that the foreign divorce has been obtained pursuant to the national law of that foreign spouse, and of course, the national law is presented before the local courts, no, and proven to. And there is proof that the foreign divorce has been obtained, no, by complying with the national law. And of course, we know that Article 15 talks about the nationality principle. Okay, the nationality principle being that laws apply to Filipino citizens wherever they are. Okay, and of course we know that absolute divorce is not allowed here in the Philippines. It's not valid in the Philippines. So it is, I think, one case, this is the Filipina, the Filipino spouse, no, was allowed to secure divorce, a foreign divorce, no, based on the national law of the foreign spouse. And I think that's not contemplated under Article 26, paragraph 2. And I think that's also violative of Article 15, okay, because of the nationality principle. Because, it is in effect, allowing foreign divorce, no, or divorce, allowing allowing divorce for a Filipino citizen. The rationale for Article 26, paragraph 2 is that, it is aimed to cure an anomaly in the sense that, a foreign spouse is allowed to secure a divorce, okay, and of course that will allow him to remarry, okay, with the marital tie having been terminated, so that the Filipino spouse will find himself or herself, being married to no one. No, he or she stays married, but there's no one that he or she is married to. So I think I can see that rationale behind Article 26, paragraph 2. But Article 26, paragraph 2 is very clear that it has to be obtained by the foreign spouse, not by the Filipino spouse. Otherwise, that will contravene the clear nationality principle under Article 15, and that would, in effect, allow a Filipino to obtain divorce, which is, of course, not allowed under Philippine law.
Again, from Justice Tiham, would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cyber crimes based on procedural grounds?
I do not think in conscience, no, I will allow an acquittal of that person, especially if the evidence of guilt is very strong. Okay. Just on procedural grounds, that should be used, to avoid, injustice because of strict application of procedural rules and regulations. But if the evidence of guilt is strong and, the kind of crimes committed is grave, no? Because it's, you said, heinous crimes, no? I don't think he should seek the person, the accused, should seek refuge on procedural matters, procedural grounds.
What is birthright citizenship? In your opinion, is birthright citizenship constitutional or unconstitutional under the Philippine Constitution?
Birthright. Is it the fact that a person is born if a person is born here of a mother of a Filipino mother or for a Filipino father, then
No, I'm just reading the question.
oh, okay.
Birthright citizenship, because I think Justice Siam asked because in the U.S. Supreme Court, it is now an issue.
Oh, okay. Because all right. So probably it must be referring to if a person is born in the U.S. Usually, then of course
Under
he
the context, but the
or she.
question now is under the context of the Philippine Constitution.
So a birthright here,
Yes.
citizenship
Is there-
here.
Is there birthright citizenship under the Philippine
Oh,
Constitution?
well, I don't think there's such a thing that if you're, if your mother, just because you're born here, you solely, I mean, it doesn't make you a Filipino citizen. I don't think that's the case, Your Honor.
Baka kasi pwedeng yun, sorry. Thank you. Question number 4. If you know only, in the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th justice? If you know only.
I don't know, Your Honor. I'm
Yes.
sorry.
How about the doctrine of rule of 4 adopted in the U.S. Supreme Court? If you know only.
Yeah, is that Your Honor for something to do with petition for certiorari? Is that rule of 4?
Yes.
Okay.
If you know only. Kung
yeah.
hindi, sa US naman yun eh.
Yeah, that's why. So if I think you have to have a vote of 4 for the court to recognize certain petitions. Is that what it
To
is?
give due course to a petition for certiorari.
Yes, petition for
If,
certiorari. Yes,
At least 4 justices
only 4
decide
justices.
to give it
Yes.
due course, it will be heard by the Supreme Court, U.S. Supreme Court. Okay, my own questions, very few only. I read your sample decision. On the basis of the rule on hierarchy of courts, your dispositive portion was to deny the petition. Okay. On page 6 of your decision, you wrote several exceptions to the rule. And under the facts given, does the case fall or does not the case fall under any of the exceptions which you mentioned?
Okay, hierarchy of courts.
Because your dispositive portion was to deny the petition, meaning to say you do not believe that it is one of the exceptions.
Yes, Your Honor.
remember your- what
I
you wrote?
also thought that the facts are incomplete. So of course, the hypothetical, it's supposed to be a hypothetical question. And I don't know if you're referring to the Senate Blue Ribbon
Farmally
Committee.
It
Pardon?
was based on the Farmally case. Farmally, who was ordered incarcerated by the Senate. You remember that case?
Yes, Your Honor. But
Your dispositive portion was to deny it.
yes, Your
The
Honor.
case does not fall any of the exceptions which you mentioned.
Well, of course, the constitutionality of the act, if there are, except for probably the denial of the rights of the
You wrote 8 exceptions.
yes, Your Honor. I
You remember
realize
them?
that, Your Honor. I realize that, Your Honor. Yes.
Not one of them.
Now
The
I have.
Supreme Court gave due course to the petition.
Yeah, I have to rethink that, Your Honor. But my main consideration was that now I think the thrust of the Supreme Court is because now more and more cases are now being filed before the Supreme Court because of this expanded jurisdiction. So the Supreme Court in later cases has said that the determining factor or determinative factor in whether it should, because it's the Supreme Court has concurrent jurisdiction with the Court of Appeals and the RTC, in petitions for certiorari. So I have read in some recent cases that the determining factor on whether the Supreme Court will assume jurisdiction over a petition for certiorari is whether only questions of law are involved, Your Honor. So,
But you enumerated several exceptions.
yes, yes. And
Not one is applicable.
I don't think it's applicable, Your Honor.
So there is no, the issues are not of transcendental importance.
No, Your Honor. Because it
There is
only
an
involves,
plain, speedy, and adequate remedy.
yes. I browsing through the exceptions, I don't think any of those exceptions is applicable in that particular
We
case,
re-
considering the facts,
we
considering the
respect
facts
your,
stated, Your Honor.
We respect your opinion
Yes,
on
Your
it.
Honor.
You mentioned earlier the rule of law. What are the four principles which, universal principles which govern the rule of law?
It escapes me right now, Your Honor.
Therefore, anyway, okay lang.
Yeah, of course, I would, immediately think of, just complying with what the law says, Your Honor, what the statute says, and of course, what the Constitution provides.
Yes.
So I would immediately think of that, Your Honor, as, observing or adhering to the rule of law. It's what following, complying with the provisions and principles under the Constitution and what the statute provides.
Universal principles. So, worldwide, international principles.
Still, it's adherence, I
Yes.
suppose, to the Constitution and the law, Your Honor. I
Exactly,
think
also.
that universally, that should be one of the principles, Your Honor.
I mean, earlier you were asked what what is expected from you if you are appointed. My question now is, what are your expectations if you are appointed?
My expectations when I am
Yes.
appointed,
Opinion lang naman.
yeah, that I don't think I have the right to expect. I think I should expect myself to just be doing and contributing to the court. I think I will have to make sure that I will prove that I deserve the appointment, Your Honor, and just focus on my job rather than expecting things from my colleagues, in the judiciary. So I will really just focus on the job that I need to do, Your Honor.
What are the essential elements of the freedom of expression?
Okay.
Only two.
Well, of course, freedom, essential elements of the freedom of expression.
Yeah, essential elements of the freedom of expression.
Okay, you express your thoughts, your beliefs, and freedom of expression can also be, verbally or in writing. Okay, and expressing your thoughts and your opinions.
I think you will recall this if I mention this. The first is freedom from previous restraint, and second, freedom from subsequent punishment. Is the prohibition, I mean, say, absolute, previous restraint? I mean,
What is that, Your Honor? I'm sorry, I didn't quite get it.
no. I will reward it. Is the prohibition on prior restraint absolute?
Okay, I don't think so, Your Honor. You know, it's not.
Can you give an example? Prior restraint.
Okay. If I can't think of one right now, Your Honor. I'm sorry.
Sample is the MTRCB, that is prior restraint.
Okay.
Oh. That's-
Yes. All right.
How
Censorship.
about exit polls by the COMELEC? The COMELEC banned exit polls. Do you remember the ruling of the Supreme Court?
Yeah. Well,
Is it constitutional or unconstitutional?
I think exit polls is when the voting is done.
Yes,
I
yes.
think
After.
voting is done, and the voter may be asked how he or she voted. I think the Supreme Court said that's fine, that's constitutional. But considering now that immediately, the results are shown in social media, there may not. I don't know if there are still exit polls at this time. Probably no exit polls anymore are done because of the speed by which people get to know the results of the elections. But
The Supreme Court said it was unconstitutional.
unconstitutional.
Yes.
Okay.
What are the tests to determine the restraints on freedom of speech and expression? Do you remember them? If not, okay lang.
The question is,
Okay, generally, restraints on freedom of speech and expression are evaluated by either a combination of 3 tests. What are those tests? If you know.
is it still the compelling state interest test? And of course, also, is it the strict scrutiny test? Is it one of the tests?
Number 1, dangerous tendency doctrine. That is the test. Number 2 is the balancing of interest
Balancing
test.
of interest test.
And the third one,
Yeah, is it the compelling,
no, clear
State-
and present
clear and present danger?
danger rule. Oh. Just one more. What are the 3 inherent powers of the state?
Well, police power, eminent domain, and taxation.
Police power. Okay. The senior citizens law. What is its basis? Taxation, eminent domain, or what?
Process of elimination, I would think police power.
Police power.
Yes,
You're
police
correct.
power.
The Supreme Court agrees with you. That will be all, Dean.
All
You're
right.
correct that the Supreme Court agrees with you.
Okay.
You're correct.
Okay.
That will be my last question.
All right. Okay.
You're excused now. Thank you for your.
Okay. Thank you. Thank you, Your Honors. Thank you for this opportunity, Your Honors.
Thank you, Justice Mendoza, and thank you, Dean Maria Concepcion, Noche. Good luck po. That concludes day 3 of the public panel interview for Supreme Court Associate Justice.